Good morning. Hello. चालू का? Am I audible?
Yes,
आवाज
madam.
येतोय का?
Good morning, madam.
Good morning, sir. We'll be starting shortly, sir. Just wait for 5 to 10 minutes more.
No issue, madam. But I am audible.
Yes, sir. Yes, you're audible.
Do you want to take this as well? No.
बाकीच्यांचे आवाज माझा आवाज बंद आहे ना? Within 5 to 10 minutes, let the people join. Good morning, sir. Hello. Kamani
Good
sir.
morning, madam. Namaste.
Should we start, sir? It's already 9.
Yes, no issue.
I think the number count is sufficient, sir. We will start it.
Ah, it shows me 46 around.
Yes, yes. They'll
Okay,
keep joining, sir, but start it.
no issue, ma'am.
Thank you, sir. So, hello. A very, very good morning to everyone. It is with the great pleasure I, Dr. Priyanka Naikwadi, Head of Library Knowledge Resource Center, Shri Shahu Mandir Mahavidyalaya, welcomes you all to this one-day national online seminar on intellectual property rights in research and higher education. On behalf of the Library Department, I extend a warm greeting to our respected Principal Sir, Dr. Vilas Patil Sir, who is chairing the inaugural function today. Esteemed speakers, participants, academicians, library professionals, researchers, and students who have joined us from across this country. Akhila Bharatiya Maratha Shikshan Parishad, founded by a team of renowned educationalists and leading social reformers of Maharashtra, it aims at educating the masses and spreading education among those who have been deprived of it from generations. We follow the footprints of these leaders. Shri Shahu Mandir Mahavidyalaya is established in 1960. It's one of the attempts of Akhila Bharatiya Maratha Shikshan Parishad to give education to the masses. It is one of the several educational units of Akhila Bharatiya Maratha Shikshan Parishad spread all over the Maharashtra. The college campus is spread over a vast area of 67 acres, and it has a very beautiful picture square campus covered with a large number of trees here. Our college has separate library building at the center of campus with we have rich and rare collection. In today's rapidly evolving academic and research landscape, the importance of this intellectual property rights, which we are going to talk in today's all sessions, cannot be overstated. As innovation and knowledge creation continues to grow, understanding how to protect and manage intellectual property has become essential for researchers, educators, and students alike. This seminar aims to create awareness and provide valuable insights into this crucial area. This seminar will be divided into 3 parts, that is inaugural keynote address by Dr. Kunal Kumar Kamani sir, later on resource persons. First is Dr. Suvarna Nilak ma'am, then Mr. Prahlad Jadhav sir. They will guide us respectively, which will cover the major aspects of IPR. We are truly honored to have with us our keynote speaker, Dr. Kunal Kumar Kamani sir, who is professor in the Computer Science Department at SMC College of Dairy Science, Anand, Gujarat. Sir, we extend our warmest welcome to you, sir, and it is grateful for us to have your presence today. Your expertise and experience in this field will definitely enlighten us all of the day. This inaugural is chaired by our respected principal, Dr. Vilas Patil sir, whose valuable guidance and support always encourages us to organize such thoughtful seminars. His very long and rich experience in teaching and administration will enlighten us throughout the day. I welcome both the dignitaries, sir, all the faculties and participants who have joined the today's inaugural session on behalf of Akhil Bharatiya Maratha Shikshan Shahu Parishad Shri Shahu Mandir Mahavidyalaya. I welcome you all. So, dear friends, your participation and engagement will make this seminar truly meaningful, and we encourage you to ask questions and share your perspectives and network with fellow professionals throughout the day. So, let us embark this exciting journey of knowing IPR in depth. Thank you once again, and welcome you all to this seminar. We will just move towards the inaugural speech of this session. I thank first of all Dr. Kamani sir, who has accepted our invitation on a very short notice. So let me introduce him today as a keynote speaker. Dr. Kunal Kumar Kamani sir is a professor at Computer Science in SMC College of Dairy Science, Kamdheni University, Anand, Gujarat. His core areas of expertise includes computer science, wireless technology, digital financial applications, ICT in dairy educations, and computer-based innovations in dairy industry with interdisciplinary research. He has completed his master's and MPhil PhD in computer science in Gujarat. He has completed 7 research different projects till the date. On his credit, there are 23 journal papers, 6 chapters in books, and 4 edited books published. He has created several ICT-based materials, methods, and conducted training and capacity programs, promoted digital literacy among rural youth and farmers through demonstration for farmers. That is very remarkable, sir. He has been awarded with Best Teacher Award by Uttaranchal University, Dehradun, Uttarakhand. And there are several Best Research Paper Awards, which are awarded to him for 3 times. So I wholeheartedly welcome you, sir, and request you to kindly address us with your insights today. Over to you, Kamani, sir.
Thank you, ma'am. Good morning, everyone.
Good morning.
Respected Principal Dr. Vilas Patil, sir, convener of this one-day national seminar on intellectual property rights in research and higher education. Respected Dr. Priyanka, madam, and all the organizing committee members. Thank you for providing me an opportunity to address the gathering. So let me start with my presentation. So for that, let me share my presentation. May I, ma'am?
Yes, sir.
Okay. Madam, is it visible?
Yes, sir, it is visible.
Okay, thank you. Thank you for confirmation. So let us start with the fundamental questions to the audience. So what is basically the intellectual property? So before that I begin, let me ask a simple questions that rise in our mind and be honestly. Every time we encounter with a few things that in our day-to-day life, for example, downloaded a research paper and we are forwarding in our WhatsApp group. Similarly, we used a graph, some sort of pictures, some sort of images from various research articles, journal papers, and we are presenting the same in our some sort of seminars without citing it. Frequently, we copy paste some sort of paragraphs, notes, some sort of published papers from some others' thesis. Okay, so I know knowingly or unknowingly we are doing such sort of things without taking permissions from whosoever is the owner. So that is the exactly why this session exists, to give you the clarity that what we can do and what we cannot with this. So actually, just I like to remind you that yesterday was World IPR Day. That is 26th April is celebrated as World IPR Day, and I think this is the right time and right platform to address this very good topic. Okay, so let me tell you why IPR matters for all of us as academicians. IPR is not it is not just a legal subject for lawyers. Okay, but in today's knowledge economy, intellectual property is the real currency of innovation. When as a student, when you complete your masters or PhD, you produce one original research, and that research has a value because you have spent in and around almost 2 to 4 years to complete that particular degree. But unless you know how to protect it, how to document it, and how to publish it correctly, someone else could claim it. At the same time, they may misuse it, or you could accidentally infringe upon someone else's work. So as a PG students, as madam narrated that most of the participants are PG students from this college. So I would like to address all the PG students, not only from this college only, but across the India, whosoever has participated. You are operating under framework set by UGC. If I belong, suppose I am belongs to agricultural university, then ICR is the body. At the same time DST, and you, and at the same time your own university. Understanding IPR is no longer optional, it is essential. Say for example, I belongs to Anand city, the milk city, the milk capital of India. So the companies like Amul, Tata, Infosys, and at the same time thousands of startups build their competitive advantages on intellectual property. Research institutes like IITs, IIS file hundreds of patents every year. Your work can be part of that ecosystem. For example, Amul's brand girl is one of the India's most valuable trademark that you have come across. That the girl with polka dots. Okay, the famous Amul girl and the Amul logo are legally registered and protected. So, as a student project that uses Amul logo without permission, even in our college poster, would technically constitute a trademark infringement or trademark breaking. So let me go through the today's session outline. Here is our journey for today. We will begin with the basics. What is IPR and what are the different types? At the same time, we will then go deeper into patents, copyright, and the trade secrets. We will specifically look into the role of institute, your college, your university in managing and promoting IPR. At the same time, in the last, we will conclude with very practical advice for PG students and researchers. So let's begin with one by one. So, what is intellectual property or IP? Until now, as a computer teacher or computer background, I was only aware that IP means Internet Protocol. But let us start with fundamental question: what is intellectual property? The word property usually makes us think of land, car, building, or any physical objects. But intellectual property refers to the creation of human mind, inventions, literary work, artistic work, some sort of symbols, name, and the designs used in commerce. The World Intellectual Property Organization, that is WIPO. Here you can see WIPO, World Intellectual Property Organization, defines IP as a creation of mind for which exclusive rights are recognized. I repeat, WIPO defines IP as a creation of mind for which exclusive rights are recognized. And intellectual property rights or IPR are the legal rights that give creators protection over their creation and inventions. For example, scientist in NDDB develops a new starter culture for yogurt production or dahi production or chicken production. That formulation can be patented. No other company can use that exact process without license. So let's go deeper by seeing the type. Yes, the IP ecosystem. The intellectual property is not one thing, it is a family of different legal protections, each designed for a different type of creation. Let me walk you through the major types. Very first is patent. For new invention and technological innovations, we are using patents. At the same time, copyright, it is used for original literary and artistic and creative work. Trademarks for brand names, logos, and symbols. Trade secrets for confidential business information and processes. We have sometimes encountered with one word, that is GI tag. GI, that is geographical identification for products tied to a specific region or area. At the same time, I would like to mention about industrial designs. If I am working For example, I am working here in agricultural university, then it might be plant variety protection. It is relevant or relevant in agriculture. So let's discuss one by one. Very first is patent. It is the innovator's shield. What is patent? A patent is government granted exclusive right given to an inventor for new, useful, and non-obvious invention. In exchange for disclosing the invention to the public, the inventor gets monopoly, the right to prevent others making or using or selling the invention for a period of 20 years. To qualify for patent in India under a Patent Act 1970, and the same time the amendment was made in 2005 regarding the invention, and it must be novel, new, or novice. It has not been done before. Inventive, it is not an obvious and skilled person in the field, and industrially applicable. It can be used in industry. So this is about the basics of patents. For example, let me give you one example. A researcher in an agricultural university develops a solar powered milk chilling unit that reduces electricity cost up to 40 percentage. I repeat, for example, a researcher here in agriculture university developed one solar powered milk chilling unit and that reduces electricity by 40 percentage. Then this device can be patented. Even a minor modification to the existing machine, if it is a non-obvious and novel, then it can be patented. India's patent office located in Mumbai. At the same time, there are various offices in Delhi, Chennai, and Kolkata. And nowadays, government is promoting patents and all these things, startups and individual innovations. The cost of this filing patent is significantly reduced. Uh, Here are some steps for filing the patents. There are basically 6 steps. If I mentioned over here, a filing patent in India is a sequential process. Step one, it is the invention disclosure and through prior art search to ensure no one else has done it. Step two is filing either provisional or complete application. Step three is provisional application. Act as a placeholder to secure your priority date while using while you finish your research. Then it comes to the publication. Step 3 is request for examination. Step 4, responding to the first examination report. Step 5, finally, if it goes well, then patent is granted. And step 6, it requires patience, but it is highly rewarding. Then we move across the copyright. The copyright is most relevant IPR. Every time we have came across this symbol C and one circle is around that C, that is the symbol of copyright. Copyright is most common and relevant IPR for all of us as an academician, whether we are as a researcher or as a student. Copyright protects original work of authorship, your thesis, your research paper, your lecture notes, your computer code, your photographs, your data tables, even our PowerPoint presentations. Here is the key principle you must remember: copyright arises automatically the moment you create and fix an original work in a tangible form. You do not need to register it, you do not need to publish it. The moment you write your thesis draft, it is protected by copyright owned by you as a researcher. In India, copyright protection lasts for lifetime of the author and plus 60 years. For example, let me give you one example. Suppose you write 10,000 words a review paper on AI, that is artificial intelligence in dairy processing. That paper, from the moment you type it is yours protected. It is yours protected by copyright. If a journal publishes it, then you may transfer copyright to the journal. But before that, please assure that read those agreements. If someone else reproduces it without your permission, then they are infringing or violating your copyright. Here, I like to mention that copyright protects the expression of an idea. I repeat, copyright protects expression of idea, not the idea itself. For example, two researcher can both write about machine learning in milk detection. Frequently, I will give the examples from which I belongs to. Okay, I am working in dairy science, so I give the example accordingly. See, for example, there are two researchers and that both are working on machine learning in milk quality detection, whether it is milk is adulterated or not, without infringing each other. As long as they are express it in their own words, they are not violating their copyright. So it is all about fair dealing. Next comes to the trademark. We have often come across the symbol like TM, that is a trademark. It is identity in the market. A trademark is any sign, a symbol. It can be word, it can be phrase, it can be logo, or combination of logo and phrase that for a particular good or services. Here you can see the words like Amul in this particular calligraphy. Amul, it is a trademark. Logos of Nike, slogans just do it. It is a logo of Nike. At the same time, the 3D shape of that particular chocolate. Uh, Similarly, trademarks builds a brand identity and the consumer trust. As then when we encounter with such sort of Amul logo, it come one brand comes into our mind and it gets trust from the consumer. For your research institutions, for example, our university logo, university name, the motto of our the motto can be trademarked. For startups emerging from research, and the brand name of your product, your computer application is a potential trademark. As I mentioned, Amul is a registered trademark. At the same time, you have heard about Mother Dairy. It is a registered trademark. Uh, I belongs to Kamdenu University. The Kamdenu University name and the logo are identifiers of a specific university or academic institution. Using this without permission, even in a research presentation, can have some consequences. If I talk about the trademark in India, trademark register is done under Trademarks Act 1999, and the registration grants for 10 years, and afterwards we can renew that protection. The symbol TM, as I have shown in this particular slide, TM can be used even without registration, but R and the circle around that, that is registration only after registration. Afterwards, trade secrets. If I want to mention about trade secret, the trade secret is a confidential business information that gives competitive advantages, and it can be kept secret. Unlike patents, there is no time limit on trade secret protection as long as the information remains secret. Let me give you one example in this regard. Uh, we always remember in this summer like cold drinks like the Coca-Cola. The formula of Coca-Cola is the world's most famous trade secret. If I talk about my dairy sector, a cooperative specific blend of bacterial strains for a premium probiotic milk product may be kept as a trade secret rather than patented, because patenting requires public disclosure after 20 years. But for researcher, the secrets are relevant when they are working on industry funded projects like DBT. Confidentially agreements and NDAs are your tools here. One more thing I would like to mention about in this ecosystem, that is GI tag. uh, GI is nothing but the geographical identification, indications. Geographical indications are special IP protections for product that are giving qualities, reputation, or characteristics attributes to a specific geographic region. GI tag protects livelihoods of communities and authenticity of product. For example, here I have shown few examples: Kashmiri saffron, Kanchipuram silk, Alfonso mango, Moradabad brassware, similarly Darjeeling tea. Say for example, Darjeeling tea, in this sequence, basmati rice, Alfonso mango, here our Kesar mango from Gir in Saurashtra, Gujarat region. GI tech products in India, GI tech products in India are very common, and there are many GI tagged items found in our India. For example, in Maharashtra, Ratnagiri Apus, okay, they are having GI tag. For students in agricultural or food sciences, GI tags are powerful tools for protecting regional food heritage. Okay, so in India, GI registered under Geographical Identification Act 1999. Nowadays, uh, so far there are more than 600 GI tags are granted in India. Let's comes to the industrial design. The protection period is up to 10 years plus 5 years can be extended. Some creativity, some legal protection is required. For example, the design and shape of chair, car body, bottle shape, watch shape, design, mobile phone back cover, that you cannot design in this particular pattern or with this particular color. Some sort of fabrics are comes under the industrial design. Now moving to the next, what happened if IPR in research context. I'm going to just give insights in IPR in research context. So why IPR is a central to the research? If I say that, if I connect IPR specifically to the world as a researcher, as a student, as a academician, research produces knowledge, and knowledge, when it is documented and shared properly, then it forms an intellectual property. The academic research process is deeply intertwined with IPR at every stage. Let me be frank, at every stage, from the literature review, where you must respect others' copyright, to your final thesis submission, where your own copyright is established. So, for any inventions that emerge from your research, which might be patentable, IPR is present throughout your research as a student, as a PG student. Every stage of research touches IPR: literature review, copyright, data collection, database rights, invention, patents, publications, copyright assignment, commercializations, license agreement. So, in short, from literature review to commercializations, at every stage you will need to come across some sort of IPR that we have discussed in the ecosystems. Here, as we discussed about IPR, let me discuss about plagiarism, the most common IPR violation in academia. The
क्या दुख
most
रहा
Hello,
पेट
madam, I am audible.
चिची कर
Yes, sir, you are audible. Please carry on. Someone is disturbing. Please carry on, sir.
Okay, okay. Uh, I was talking about plagiarism, the most common IPR violation, that was knowingly or unknowingly. uh, that was faced in our academic domain. The most widespread IPR academic institution, that is plagiarism, presenting someone else's work, presenting someone's idea or expressions as your own without proper attributions. Now, as per UGC regulations on promotion of academic integrity and prevention of plagiarism in higher education institute, established in 2018, clarifies plagiarism into several uh, different levels, starting from level 1, 2, 3, and 4. Level 1, up to 10 percentage of similarity, minor similarity and minor penalty can be fined to the researcher. Similarly, at level 2, that is up to 10 to 40 percentage similarity found, then major revision and resubmission is required to the researcher. Level 3, 40 to 60 percentage similarity, deregistration of one semester. Be cautious. At level 4, above 60 percentage, deregistrations for the entire program. Most universities use softwares like Urkud, Authenticate, or Turnitin to check thesis and paper submissions. But remember, plagiarism is not just a software problem, it is an ethical issue. For example, as a PG student, copies 4 paragraphs from review paper published in a journal and paste them into a literature review sections of our thesis without without any quotation mark or citation. Even if the paper is cited in reference list, this is plagiarism. The idea may be from paper, but the expression, the words, are someone else's copyright. So please be sure while dealing with copyrights. Just a second, please. Huh. Now we have gone through these 4 stages, 1, 2, 3, 4. We have also discussed some sort of tools, proper attribution and citation practices are there. For example, the solution of plagiarism is proper citation and attributions. When you choose someone else's idea, we choose someone's data, figure, or expression, you must acknowledge it. There are some sort of standards or citation styles. For example, APA style, commonly used in social science and management research. Chicago and Turabian style, used for humanities sector. Similarly, for medical science, some sort of NLM and Vancouver style is there. And if I suppose I belongs to agriculture, then in agriculture science, uh, we are under the umbrella of ICAR, that is in Indian Council of Agriculture Research work. The APA styles for particular journals we generally followed. For example, a figure showing milk processing flow chart from the NDDP annual report. रिपोर्ट मस्ट बी cited as a source. हम लोग उसके नीचे लिखते हैं source, then NDDB report 2023 page number 45, either below the figure or in the caption. Simply listing in the reference is not enough. Now we come across the next thing, that is open access or paid journals. Here is the something very important for every researcher. When you publish in a journal, you are usually asked to sign a copyright transfer agreement, जिसे हम कहते हैं CTA, that is copyright transfer agreement. This means you are transferring the copyright to your paper to the publisher. After that, you may not legally post the PDF on ResearchGate without permission. ज्यादातर हम लोग यही मिस्टेक करते हैं. इवन आफ्टर पब्लिशिंग दैट आर्टिकल इन अ पर्टिकुलर जर्नल, we are uploading on ResearchGate without permission. This is why open access publishing is gaining importance. Under open access, the author retains copyright and and the work is freely available to all. Many funding agencies like DBT, ICAR, and DST now mandate to open access publication. The beauty of the golden open access is the published version is freely available. Again, green open access means yourself archive a preprint on your institution's repository. Third one is it is a combination of both, that is hybrid. The journal is subscription based, but you can pay to make your article open access. For example, let me give you one example in this regard, in this context of open access. If you publish an article in a Springer journal and sign a CTA, standard CTA, that is copyright transfer agreement, you cannot legally upload that paper's PDF to ResearchGate. Yes, but you can upload your accepted manuscript, the version before journal formatting. This is a green open access, that is green OA. This is the difference between open access and the paid journal. At the same time, data rights. Okay, I am coming to this. Just before that, I want to mention about data rights and database protections. Since nowadays we are using a different database, and particularly I belongs to IT background or computer science. Data is a new thing, or it is always a boom or buzzword in any research. So data has an IP implication too. The data set you collect, the data set you compile, and you clean that data during your research can be protected under copyright law. A database that evolves subsequent creation, selection, and arrangement of data can be protected. However, raw data, that is factual information, cannot be copyrighted. What protected is creative expression or substantial investment in compiling and arranging the data. Let me give you one example over here. For example, you spend 18 months of collecting milk quality data from 500 farms across the Maharashtra, entering into a structured database with custom parameters and quality flags. The database as a compilation can be protected. Another researcher cannot simply copy and republish your entire database, but they can use the underlying factual data if they compile it independently. Now, in this context, I want to mention about inventions from the research. This is a critical question for majority of the postgraduate students, never ask until it is too late. If you invent something during your research, who owns the patent? The answer depends on your institute's IPR policy. In most university, if the invention was made using institutional resources, facilities, and funding, the inventions owns the institute owns the patent, not individual researcher. So you may be the named as an inventor, which is a matter of right and recognition, but assignee on the patent would be your university only. However, if the research was purely on your own time, with your own resources, and has no connection to your institution duties, the inventor owns the patent. For example, a PhD student at IIT Bombay invents a novel filtration membrane in dairy influent treatment using institution's lab. उसने आईआईटी बॉम्बे का ही लैब का इक्विपमेंट्स यूज किया है, और उसको फंडिंग मिला है आईसीएआर से या डीबीटी से. The patent belongs to IIT Bombay only. The student is named as an inventor and may receive a share of royalties as per institution policy, but cannot be file a patent independently. So always ask, does my college or university have IPR policy? What does it say about inventions? This is the right to know as a researcher, as a student. After that, one more thing comes into the picture, that is technology transfer licensing. Once invention is patented by institute, हाउ डज इट रीच टू इंडस्ट्री? किसी ने पेटेंट तो फाइल किया, लेकिन इंडस्ट्री तक पहुंचेगा कैसे? थ्रू टेक्नोलॉजी ट्रांसफर एंड लाइसेंसिंग, TTL. An institution can license its patent technology to company exclusively or non-exclusively. It exchange in exchange for royalties or lump sum fees. This is how research create economic values. Say, for example, our college, that is SMC College of Dairy Science, has transferred several dairy technologies like UHT milk, ultra high treatment milk process adoptions. At the same time, so we have created new microbial bacteria to for probiotic formulation to the dairy cooperative sector. At the same time, the institutes like IIT Kharagpur has licensed agricultural drone technology for agricultural technology startups. Uh, the Kamden University, from where belongs to, uh, Kamden University research on indigenous cattle genetics has the potentials for similar licensing to animal breeding organizations. So this is all about technology transfers and licensing. Now we are going for patents in depth. How patents work, what can and cannot be patented. As we have gone through the steps, 6 steps of patents, now what can or cannot be patented? Not everything can be patented. The Indian Patent Act 1970 specifically excludes several categories. Let me highlight the most of the important ones for researcher. Just a second, please. I'm coming to that slide only. Yes. The mathematical methods and abstract theories cannot be patented alone. Computer programs as a software cannot be patented, but the software that produces technical effect can be patented. Scientific discoveries, discovering a natural law and processes cannot be patented. Methods of treatment of human body, medical treatment procedures, traditional knowledge. For example, here I have shown the examples of neem, turmeric, anything that is already traditional knowledge, and again it is documented in TDKL. Okay, that cannot be patented. For example, let me give you one example. A new algorithm for predicting milk adulteration using machine learning. The algorithm alone cannot be patented, but if you build a device, instrument, a smart milk testing instrument that uses algorithm, and the device and its method can be patented as a technical solution. As I have mentioned, TKDL, that is nothing but traditional knowledge digital library. In recent parts, US has taken patented for neem and granted on neem oil extraction, but it was issued and it was rejected since because India has shielded it as a traditional knowledge digital library. Then come to the next open source that I have mentioned. Yes, here few Creative Commons licenses are here. For example, Creative Commons licenses are brilliant innovation that allows creator to share their work with specific permissions rather than all right reserved. CC license means Creative Commons license says some rights reserved. There are 6 main types. Here I have mentioned very first is CC by attributions only, most permissive. At the same time, CC by SA means attribution plus share alike. If you build on it, use the same license. Next is CC by NC, means non-commercial use only. Next is CC by ND.
Sir, you are not audible. Hello, sir.
Yes, sir. Yes.
Hello, Kamani sir.
Hello.
Hello. Kindly wait for 5 minutes as there is problem from Kamani sir's side. We'll just see to the problem and we'll join it within 5 minutes. Please stay tuned. Good morning, everyone. As there is some technical problem from Kamani sir's side, it will be maybe taking 5 to 10 minutes. So he has almost covered all the factors and all the PPTs of his. So we'll just conclude it. I'll just say that thank you, sir. Thank you, Kamani sir, for you have almost covered all the aspects of IPR as a keynote speaker. You have covered understanding of IPR is very important as far as the research and higher education is concerned. Its spectrums, copyright issues, and trademarks, everything was elaborated with a very beautiful presentations of PPT slides. Then geographical indications you talked on, industrial designs, IPR in research, plagiarism tools, etc. Open access, Creative Commons, etc. Things were also covered, which are importantly covered, should be covered in IPR. So best practices also you have talked on this session. I thank from behalf of Shri Shahu Mandir Mahavidyalaya for giving such an wonderful insights on IPR. Now I request our principal, Dr. Vilas Patil sir, to give the chairperson's remarks.
Thank you, Anam. Good morning to one and all. Respected keynote speaker, Dr. Krunal Kumar Kamani, esteemed faculty members, dear participants and students, a very warm welcome to all of you to this inaugural function of the one-day online seminar on intellectual property rights in research and higher education. It is indeed a matter of great pride and honor to have with us today Dr. Kunal Kumar Kamani, Professor in the Computer Science Department at SMC College of Dairy Science, Anand, as our keynote speaker. We are grateful for your presence and for sharing your valuable expertise on this highly relevant and significant topic. In today's knowledge-driven world, intellectual property rights have emerged as a cornerstone of innovation and academic excellence. As research and higher education continue to evolve, the need to protect intellectual creations, be it inventions, literary works, software, or designs, has become increasingly important. Awareness and understanding of IPR not only safeguard the rights of creators but also promote ethical research practices and encourage the translation of ideas into impactful solutions for society. This seminar aims to provide a platform for scholars, educators, and students to deepen their understanding of IPR, explore its various dimensions, and appreciate its role in fostering innovation and entrepreneurship within academic institutions. I am confident that today's sessions, especially the keynote address, will offer valuable insights into how we can integrate IPR awareness into our research culture. I commend the organizers for their initiative and meticulous efforts in arranging this seminar, and I extend my best wishes for its success. I also encourage all participants to actively engage in the discussions and make the most of this opportunity. With these words, I formally inaugurated this one-day online seminar and wish you all of you a fruitful and enlightening experience. Thank you. Thank you very much.
Thank you. Thank you so much, sir. I take this opportunity to thank our keynote speaker, Dr. Kunal Kamani, sir, and our chairperson, Dr. Patil, sir, for enlightening us on this today's topic, IPR. I regret that Kamani, sir, is not able to give the answers of yours, but once you join, I'll make sure that if there are any questions, we will ask them through YouTube chat box, or you can keep your questions in the YouTube chat box or even in the Zoom platform. So we'll continue that. Just after 5 minutes break, we'll continue the next session. Stay tuned. Hello, Suvarna ma'am, have you joined? Hello.
Yes, I'm here only.
Thank you, ma'am. Thank you. So should we start it?
Yeah, no problem.
Okay. So welcome back to the seminar again. Once the Kamani sir will get in touch with us, we'll join in for the question and answer sessions later on. So let us move towards the next technical session in which Dr. Suvarna Nilak Madam will guide us regarding innovation, patents and technology transfer. And the session will be chaired by Dr. Sunanda Vagmare ma'am, who is Professor of Department of Psychology at our college. I will introduce both the dignitaries briefly here. Dr. Suvarna Nilak ma'am is Associate Professor and PhD Supervisor at ILS Law College, Pune. Dr. Suvarna Nilak is a member of faculty at ILS Law College, a leading law college in India. At ILS, she is currently heading the Legal Aid Center and Center for Technology, IP and Media. She has earned her doctoral degree from Savitribai Phule Pune University in 2016. She has more than 20 years of teaching experience to her credit. Her areas of interest primarily include IPR, administrative law, and environmental laws. Her academic research revolves around IP, public policy, and clinical legal education. She has participated and presented papers in various number of conferences, seminars, and published articles in reputed national and international journals. Ma'am has designed a certificate course in intellectual property rights laws for Indian Law Society, Pune. She has been invited as resource person in various national and international academic events as well. She has organized variety of curriculum and co-curriculum activities at ILS Law College. I also I welcome you, ma'am, to this seminar. I also welcome Dr. Sunanda Vagmare, ma'am, who is chairing this session. Professor Dr. Sunanda Vagmare, ma'am, is dedicated academician over 18 years of teaching experience in psychology. She holds MA Psychology, B.Ed, SET, PhD. She has been serving since 2008 as an assistant professor, associate professor, and professor at the department. Her specialization includes clinical psychology, juvenile delinquency, parenting styles, positive psychology, and mental health. Professor Sunanda ma'am is accomplished academician and researcher with significant contributions in psychology, published 26 plus research papers in peer-reviewed UGC care listed journals, Scopus Index journals. She has authored 2 books and contributed to 5 chapters edited volumes. She has also developed ICT-based teaching contents. Dr. Sunanda Vagmare ma'am has successfully completed one UGC-funded minor research project as well. So I welcome both of you for this session on behalf of college ma'am, and I request Dr. Suvarna ma'am to kindly guide us. Over to you, Suvarna ma'am. Thank you. Hello.
Thank you, ma'am, for the introduction, and thank you, Sunanda, ma'am, for joining as our chairperson. So, respected chairperson, principal of the college, the faculty members, and the student participants who have joined for the session. I hope I'm audible as well as visible.
Yes, ma'am.
Yes, ma'am. Yes.
So, the session which is allotted to me is innovations, patent, and technology transfer. We'll share the screen. Whether the screen is visible, Priyanka?
Yes, ma'am. It's visible.
Okay. So there are 3 topics which are quite interrelated, which I'm supposed to cover in this session: innovations, patent, and technology transfer, and they go hand in hand. They are very closely associated to each other. Before we go ahead with the patents, I'll just briefly introduce the concept of intellectual property. I'm sure the previous speaker has extensively spoken about the intellectual property. What is intellectual property? What are the various kinds of intellectual property and all to you? But I'll just tell you why intellectual property and how it is relevant in the patents and the technology transfer. So when we talk about intellectual property rights, there are three terms. One is intellectual, second one is property, and the third one is right. Intellectual is where a person's human contribution or intellectual capacity is used to create a property, and because of the property created, property is a bundle of rights. So when you have a property by which is created by using your brain, by using your intellectual capacity, you have every right to have protection to the same. And that is why the element of rights and the law comes in. So you have intellectual capacity rather. By using this intellectual capacity, you produce a work. Uh, because of the work produced, you are entitled for certain rights under the law. And here comes the intellectual property law. So intellectual property law basically protects your property which is created by using your own brain or by using intellectual capacity. Now how it is distinctive than the other properties? We have two types of property, like tangible properties, intangible properties, intellectual properties, and other properties. Like when I say I have properties, it could be a flat or it could be a land, or it could be any, like the laptop which I'm using for the presentation is my property. So I own a certain things, and uh, here I have every right to possess them, I have every right to own them, I have every right to sell them, because I am the owner of the property. And similarly, there are certain properties which are created by using your brain. Now, when I say I own a laptop or I own a flat, how I become a owner? Where I pay for the same. So I go to the shop, purchase a laptop, the invoice is generated in my name, I make a payment, and then I become the owner. Similarly, in case of the flat, I basically look for a property suitable to my needs, then I contact the owner, then there will be some kind of discussions when both the owner and the buyer, that is me, are on the same page. Then we decide upon the terms and conditions, then we go to the sub registrar's office, then I like whatever the payment of consideration is there, then I pay, and then I become the owner. Now, when you come to intellectual property, here how the properties are created? By using your brain. Like taking a photograph. If a photographer is clicking a picture and the same picture is being clicked by me, you will see a lot of difference in the same. If you ask me to sing a song, I will sing, but not like a professional singer. If you ask me to write the lyrics for a song, I won't be able to write because I don't have that intellectual capacity to produce that particular work. So here I have to invest uh, my intellectual labor for creating a property. But when it comes to other properties like laptop or this thing flat, or for that matter any other property, then you have to have sufficient amount of money or consideration. But when it comes to intellectual property, for owning the property, you need to have some kind of intellectual capacity. I agree, there are persons who can who can become the owner even though they are not creators, but like by paying consideration, but that is different this thing type of ownership. So here, prima facie, person who creates the property is considered as owner. Now, what are these properties? That is already covered by the previous speaker. Like it could be copyright, it could be trademark, geographical indication, design, patent, semiconductor layout design, trade secret, plant variety. In some cases, the traditional knowledge also. Then we have the confidential information also. So generally, these 10 types of properties are considered as intellectual property. Two I could not include in the this thing, like design of the slide. So I have not included them, but you can keep them in mind. The two which are not included are traditional knowledge and the confidential information. The confidential information may be closely associated with the trade secret also. So these there are like roughly 10 types of intellectual properties. So they are created and then they are protected under the law. So briefly to discuss them, when your original literary artistic work is there, like if you are a songwriter or a playwriter, that is protected by way of copyright. If you have any brand name, symbol, logo, then that is protected by way of trademark. If you have some kind of innovation or invention, like mechanical device, or say the technology which is used for the UPI payments, that is protected by way of patents. So roughly, that's basically a very rough distinction between these intellectual properties. Now, I have used the picture from the CPAM website, the Center for Intellectual Property Management website, which where they have used the old Nokia phone to display or to show all types of intellectual property in one with one design. Like if you see here, the outer structure of the phone is protected by way of design. The technology which is used for the mobile is protected by way of patents. The Nokia is a trademark, so it is used by way of trademark. Then there are certain chips. These chips are protected by way of integrated circuit layout design. Then the Nokia tune, which you must have heard, the old one, that is protected by way of copyright, as well as this tune is also entitled for a sound trademark. So one simple phone has all intellectual properties with it in it. Now, it's not that only one patent will be there. Trademark could be one or more than that also. Copyright ka example, you have the tune which is copyrighted, as well as it could be a sound trademark. There could be multiple chips, then all of them will be entitled for the this thing, integrated circuit. When it comes to patent, then there will be number of patents, and I won't be wrong if I say there will be thousands of patent in every mobile phone. Now we know that there are two competitors in the market when it comes to mobile phone. One is Samsung and the other one is the Apple or iPhone. Now the price, and you will see a lot of pricing difference between these phones. Even though the features may be very attractive in terms of the outer look of the phone, it could be very attractive when it comes to Samsung. But when it comes to cost, the Apple or iPhone cost much more higher. The reason is the kind of patents which they have that increases the value of the final product, and that is your iPhone. So here, that when you have intellectual property, you are entitled for certain economic benefits, and that is why we need to protect the intellectual property. So as I told earlier, intellectual property refers to the creations which human beings creations rather, where he uses his intellectual capacity. So these leads to technological advancements. Now here, if you go here, now do we use this phone? The answer is very simple, no. Why? Because of the technological advancements, we have the mobile phones which are better in terms of looks, better in terms of user friendliness, better in terms of technology, better in terms of safety, security, and therefore these technological advancements is the result of the intellectual property. Had there not been inventions, intellectual properties, or patents, then definitely technological advancements could not have been there. Now, there is also socio-economic development because of the intellectual properties. How? The previous speaker was talking about the number of patents. So, more number of patents leads to more number of, the value of the product increases. The net worth of the product increases because of the number of patents which are associated with the product. And that obviously leads to socio-economic development. One example, we can take here is Jaipur food. So Jaipur food is a patented product. Now that has been a blessing for the people with the physical disabilities. So people are able to walk like a normal person because of the Jaipur food. So we can see the society ka development is there. Now this is not only the development in terms of money, but overall well-being, physical well-being of the person has been taken care of by the Jaipur food. So uh, this leads to the intellectual properties, also leads to socio-economic development. Then when we create these properties, we give monopoly to these properties, the owner of the properties. Now when the monopolies are created, so creation of monopoly is a kind of incentive to a person. So when you are sure that nobody else will use my patented product, so I'll be able to. Hello. So if the product is patented, or if I have a copyright or trademark with my intellectual property, I will be free from, or rather I'll be free from any fear of misuse of the property or any kind of infringement of the same. And therefore more this thing, like I'll be able to focus more upon the product rather than taking care of the infringement and all. Also, when the intellectual properties are created, they are always time bound in nature. So for example, patent is protected for a period of 20 years. So what happens after 20 years? It comes into public domain, and then any other person than the patentee can use this patented product. Now if you see this, like for giving a simple example, the product of any medicine which was patented before 20 years, uh, that the cost will be reduced to a great extent when it comes into public domain. Now you may say, array 20 years is a very long period of time, what is the utility of the same and all? No, it doesn't happen that way. If you look at the patent ka process, which I'll be describing later, the 20 years duration is actually not very lengthy one. Rather, people are insisting for more period of patent protection. Within a period of 20 years, there is hardly any scope for the commercial exploitation of the product. And anyways, after 20 years, it comes into public domain. So any person from the general public can use the patented product, can use the patented technology for the better, for its own benefits or to the benefit of the people at large. And therefore, it is very important to protect the intellectual property, not for the individual gain, but for the gain of the society at large. Now coming to the patents, which is my core topic for today's discussion. Patent is nothing but a right conferred on a person for the invention. So you for having patent, you need to have an invention. So patent is nothing but this thing, like the exclusive right conferred upon the patentee against the invention which he or she has. Now, patent may be granted against the product or a process. To simplify it, we can take example of a this thing, like surgical method. So, treating person, let's say there is a knee replacement surgery. Now, knee replacement surgery, there are two things. There are some medical equipments which are used for the surgery and the process of the surgery. So both of them are entitled for the patent. So one is a product, that is the equipments which are used for the surgery, and the second one is process of actual knee replacement. Now in India, this process in terms of this thing, medicinal products or rather surgical processes are not patented. So the only product will be patented, but uh, we should keep, sorry, the products are not patented, the processes are patented. So here both product as well as process is entitled for the patent. So you can make an application for the grant of patent in case of a product or a process. The rights which are granted are territorial in nature. It means if you have patent in India, you can use the patented rights only within the territory of India, not outside the territory of India. So this we should always keep in mind. So if you think that my product needs protection outside India also, like in America or in any country in Europe, then you need to file a separate application for the grant of patent in those respective jurisdictions. The patent term is 20 years from the date of filing of the application. So there are two dates. One is the date on which actual patent is granted, and the first date is the date on which the patent application is submitted. So the term of the patent actually starts from the date of filing of the application. So this is this is very important for all of us. So if I am filing for the patent, say today, that is 27th April 2026, and uh, by going through all the processes, if I get a patent after 4 years, then the date of patent will be the date of application, that is 27 April 2026. So here you will see I will get only 16 years to actually come for the commercial exploitation of the patent. So though the period is for 20 years, since the patents are granted from the date of application, actually the patentee gets a very limited or less time for the commercial exploitation of the patented product or the process. And if you have a patent, then you have every right for filing a suit of infringement against the person who has violated your patent. Also, we need to keep in mind that registration of patent is mandatory in India, like copyright, unlike copyright and trademark. In copyright and trademark, what happens? You may register, you may not register. But the moment you create the work, you are entitled for copyright. The moment you create a logo and apply it for use it against the this thing, goods or services, and put them for sale in the market, you are entitled for the trademark. That doesn't happen in case of patent. So you need to apply for the registration. You have to complete the process of registration. There are various stages in the registration. I'll discuss them one by one. Once you complete the entire registration process, you will get a patent, and then only you will be entitled for using the patent for the commercial benefits. But in case of copyright and trademark, as I told, the moment you create these works, you are entitled for the protection. Now, why patent? There are 4 reasons for the patent. It's basically an asset. So the previous speaker, I was listening to him for 10 minutes, 10-15 minutes. So there he was talking about the patent portfolio. Now, if you look at the patent portfolio of India, America, China, America is America and China. They are they have these are two countries in the world who have major this thing. They have the largest number of portfolio holders of patents. So when you have the patent with respect to any product or technology, that adds value to your business. Like for example, if you have patented the technology, like UPI ka example, if you take, UPI is patent, the process is patent. So a person who is having this business, who owns this, who is the proprietor of this business, even though his reach may be limited, he will be the biggest, his entity will be biggest, this thing. In terms of economic valuation, because of the patent portfolio. I gave you example of Apple iPhone rather, and the Samsung. The cost of the phone is more because of the patents which are associated with the phone. Then recognition, obviously, Apple has in terms of the brand value, in terms of the image, in terms of the position in the market. Apple is in a much better position than this thing, Samsung, because of the patents which they are holding. Then third reason is insurance. Insurance in terms of the exclusive right or monopoly for a term of 20 years. So you will have 20 years to commercially use your product or a process because you have patented the same. And lastly, deterrent. Deterrent in a sense, you will be able to prevent others from using the patented product or process because you have exclusivity. So these are four major reasons for the patent protection. So if you are in a position anytime for creating any innovation or invention, I will suggest you to immediately apply for the patent because patent adds value to the product. So nowadays people are also giving the details of their IP portfolios in addition to their general net worth. Also, if you look at the net worth of the big industries, then one of the key element in their net worth is the their IP portfolios. So here, these four reasons, as I told you, basically are the reasons for having patent registered in your name if you have. Again, like creation of an asset, commercialization, selling, licensing, you can do so. I will give you very simple exercise like whatever product you have in your hand, just or any cosmetic products which you use, just look at the manufacturer's details. Many of the times, the products are either imported or licensed, or they may not be directly manufactured by the original patent holder, but he will give licenses to other companies to produce or to manufacture them. So here, by doing so, they earn a lot of money. One simple example I have, this is a Coca, this thing can, which you must have seen or either you might have used also. So you can see the opener, a can opening system of the Coke is actually patented. Now, the inventor or the patent holder of the same has licensed it to Coca-Cola. Okay. So, this bottle of Coke is not patented as such, but the can opening system which is used in this bottle is patented. Now, the patentee here is different. It's not the Coke. So this inventor has licensed it to Coca-Cola, and how much he is charging? 1/10 of a penny per can in UK currency. Okay, penny, 1/10 of a penny, it will be very less amount. It's like if you compare it to 1 rupee, then like only 10 paisa or 1 paisa of per can for per can. But if you look at his overall earning, how much he is earning during the validity of the patent for those 8-9 years during which he was a patent holder, he has obtained 1,48,000 pounds on royalties. Okay, now 1,48,000 of pounds per day. So this much royalty he has earned because of the sale of the Coke is in that number. So this is why we should go for the patent protection if you have any technology, innovation or invention with you. Now what can be patented? So as I described to you earlier, there are two things which we need to keep in mind for the time being. There should be a product or a process, and three things rather, a product or process should be there. It should satisfy the criteria of the patentability. There are three major criteria: newness, inventive step, and the third one is capable of industrial application. And lastly, it should not fall under section 3 and 4 of the Patents Act. Now I'm exclusively referring to the Indian Patent Act. So these three things we should keep in mind. The first one is there has to be a product or process. Then it should satisfy the essentials of the patent or requirements of the patent, that is newness, inventive step, and the industrial application. And it should not fall under the statutory exclusions which are mentioned in section 3 and 4 of the Indian Patents Act. Now, moving to the next one. Again, these three essential steps which I told you here, newness, inventive step, and the industrial application, I will describe them one by one. Now, novelty or new invention is the first essential of the patent. So, there are three things here again. When we talk about the novelty or the new invention, it should not be published in any document anywhere in the world. See, we insist when the patent is granted, we say that the protection is applicable only in India. Okay. But when we talk about publication here, and when I'm saying that it should not be published in any document, it means publication should not be there anywhere in the world. So we can actually see what kind of precaution has been taken while granting patent in India. So we have very rigid system for the grant of patents in India. Rather, we are being criticized for that a lot. But see, in India, we have tried to have a balance between the individual rights and the rights of the society at large. And therefore, the threshold of the patent is very, very high, very, very rigid also. Secondly, it should not be used anywhere in the world. It should not be publicly used anywhere in the world. Why publicly? Because see, if I'm working on a technology, if I'm involved in a research and development, obviously it is being used somewhere. But that is why we insist that it should not be publicly used anywhere in the world before the date of filing of the patent application. So these three things we should keep in mind, that it should not be published in any document, then it should not be used publicly before the date of filing for the application. Now, suppose I am working on a patent or I'm working on a technology and I write a research paper on the same and is published in a Scopus Index journal. So that is an exemption. Okay. So that there we cannot say that it is published and therefore patent shall not be granted. Since it's a publication for in a journal, then that might be exempted and you can still apply for the patent. Second one is inventive step or non-obviousness. Now, see, I'm a faculty, I'm teaching law, and suppose I am attending a workshop on artificial intelligence. So there are a lot of technological aspects of artificial intelligence which are being explained in the workshop. Now, for me, everything will be new. Everything will be non-obvious. Everything will be considered. I will consider everything as a this thing like inventive, but that may not be the case. So when we say the invention must be non-obvious, it must be must involve inventive state. It means it should be not obvious. It should be not obvious for a person skilled in the art. So a person who is a technology expert, he should say that this invention is not obvious to me. Okay. So when the moment he say it is obvious, then the non-obviousness or inventive step ka element will go away. So a person who is a computer engineer who is attending the same workshop on artificial intelligence, he will look at that workshop or he will look at the technology from a different perspective because he already has the basic knowledge and all. He knows how the technology works. So here, threshold of inventive step is again higher. So even though I am a faculty of law, I have earned my, like I have the highest qualification and all, that doesn't matter here. I am not a person skilled in the art. Who is person skilled in the art? It's a computer engineer. And therefore, we have to see whether he considers this invention as a non-obvious or not obvious, and or whether it involves inventive step or not, and then only we will go ahead to the third step, that is industrial utility. So industrial utility should be there. It means it should be capable of being made or used in the industry. So you should actually use the patented product in India or process in India. It should have some industrial utility, it should have some industrial capability, then only the product or process will be patented. So industrial, without industrial utility, you cannot apply for the grant of patent. You have to describe everything in the patent application itself. Okay. So moving ahead to some patented invention, I have listed one which are very common. Again, I have referred to CPAM ka website. This ink which is used in case of voting is patented. This equipment which is used in the agricultural uh, in agriculture is patented. This steaming this thing pot is also patented. The stapler is also patented. So uh, when we say patented, the examples I have chosen very specifically, because when we say patented, it is nothing very hi-fi thing. It is very closely associated to us, very closely associated, affecting our daily life. And that is why we should have at least basic understanding of the patents. These are some of the examples of non-patentable inventions in India. I'll go through them one by one later. So, what is important for the time being is that we have to have three essential criteria of the patent, that is novelty, inventive step, industrial utility. If you have these three, then you can apply for the patent. So let us presume that I have invented this thing technology, and it satisfies all these three steps. Like for example, I have invented a process where from using the garbage, I am able to produce the oil which will be used in a like a two-wheeler oil. Okay, so that is what my invention is. Now, even though I have invented it, I have satisfied all these three criteria. That doesn't mean I will be entitled for the patent immediately. No, I have to satisfy the fourth element also, which is listed here, that must not fall under statutory exclusions which are mentioned in section 3 and 4 of the act. What is there in 3 and 4? So the list of the inventions which comes here is basically, they are listed in section 3. The last bullet in the slide is from section 4. Other than that, other elements are taken from section 3 of the act. Now moving ahead to the next, what is not patentable in India? So couple of examples were given by the previous speakers also. Now, for example, there are certain inventions which may be frivolous, which may be contrary to the well-established principles of law, natural law. Then that may not be patentable. Like, can you invent a machine which gives 100% performance? That is highly impossible. So it is frivolous invention. It may not be patented. Perpetual machine, again, that is against the principles of natural law. So it is not patented. Then again, moving to the next one, you can just skip the sections. Just look at the second part. So the inventions which are causing serious prejudice to human, animal, plant life or health or to the environment is not patented. Simple examples are taken here. For example, I have invented a machine which may be used for gambling. Now, gambling is illegal in India. It is prohibited in India. So, I may have invented the machine. I am satisfying these three criteria which are listed in the previous slide. That is newness or novelty, inventive step, and the industrial utility. But since the gambling itself is prohibited, is illegal, so the patenting of gambling machine is impossible. Secondly, I have invented a device which will be used for housebreaking. So for a robbery, this machine could be used. Now again, this is against the law. Housebreaking is prohibited. Therefore, the invention may be very innovative, but It is not patented. It cannot be patented. Third example is biological warfare material or device. So right now there is war between even though there is a ceasefire, but Iran America ka war, if you consider, there is a possibility of use of biological weapons. Now, if somebody has invented this technology, then the same is not patented in India at all. Some countries may patent it. India has taken a very strong stand on this. We don't at all patent the same. Then weapons of mass destruction, that is also not patented uh, because it is against the human being. It is against the this thing, like against the basic principles of law. Therefore, the same is not protected as a patent in India. Moving ahead to the next one. Now, there are certain very interesting examples here. Now, if you discover a mine which has a lot of natural gas or a mineral, mine is invented, is discovered rather. Now, it's a mere discovery. It's a mere discovery. You have not invented it. Is there any newness? The answer is the mine might be new, but the minerals or the natural gas component which is being found there is not a new phenomena, because it's a discovery. There is no inventive step as such, so it is not patented. Now we see in the news that certain microorganisms are being discovered. They are already in nature. So these microorganisms, natural gas, mineral is already in nature. So it is not invented as such. It is mere discovered. So when there is discovery of any such living or non-living substance in the nature, then that is not patented in India. Okay. Now moving ahead to the next one. In India, we use neem. In Marathi, it is called as kadulimb. So there are various medicinal properties of neem. Now, if by any chance, if you come across a new property of the neem, are you will you be able to get patent for the same? The answer is no. Then, there are a lot of medicines which we use. So, for example, I took the example of aspirin. Aspirin is used for certain medicinal purposes. Now, if I found a new use of aspirin, like it can be used for prevention or curing the cancer, can I get the patent for the same? The answer is no. There is a very famous case of Novartis versus Union of India. Let us not look at the same from the point of view of a lawman. Rather, let us look at this case from a layman's perspective, like you and me. Now, see, this case is very simple and very interesting also. There is a medicine which is used for, say, treating a particular ailment. This medicine is in a form of a tablet. Okay. Now, there are two forms of medicine as of now. One is you can consume it orally. Oral consumption could be there, or there could be injection. So here there is a oral form. The medicine is in a oral form. Okay. Now someone works on the same and he comes with a injectable form of the same injection. So form is changed. Form is changed. The content remains same. But because the form is changed, now that is more this thing effective, because when you take any medicine in the oral form, then very less amount is used for actually treating the disease or whatever ailment you have, because almost 50-60% is this thing is becomes a waste. But on the other hand, if it is taken in a injectable form, then almost 90% efficacy is there to the medicine. So when a person is, to put it in a simple manner, if a person is having a very high fever, then doctor gives him injection, because then fever is reduced immediately. But if there is a mild fever, then doctor doesn't give injection. He gives crocin, because because he knows that only this much amount of medicine is sufficient. So here, because of this, like this injectable form of this cancer medicine was applied for the grant of patent. So here Indian Patent Office took a stand that it's mere discovery of the new property or new form, rather new form of a already known medicine. So this new form should not be given patent, and this view was accepted by the Indian Supreme Court. Uh, but that doesn't happen in America. America says that everything under the sun can be patented. So their threshold of patentability is not very rigid or very high like India. So they can apply for, any person can apply for like these mere discoveries or minute change in the form. You can apply for the grant of patent in America, but the same is not allowed in India. So here the form is changed, but the content of the medicine, the molecules of the medicine remain same, and therefore the patent was not granted in India. Moving to the next, like mere admixture of existing properties, like combiflam. If you see, it's a combination of paracetamol plus brufen. So that is not, that cannot be patented. Okay, so similar example is mixing sugar and color in a form water, and color in a sense like obviously the permitted colors and the preservatives, and if you come up with a soft drink, then the same will not be patented. Why? Because this, it's a substance which is obtained by mere admixture of the properties which are already known. Then simple other example is which is prohibited from the grant of patent, that is arrangement or rearrangement of the products which are working independently, like umbrella with a fan. Umbrella is there, fan is there, but if you are coming with a umbrella which has fan fixed to it, then it cannot be patented in India, because we say it's a mere arrangement or rearrangement of the products which are already in place. Now, other example is method of agriculture or horticulture is not patented, like cultivation of algae or producing new form of a known plant, preparation of an improved soil. So someone is like, we know that the quality of soil is being degraded these days. So people are working on improving the quality of the soil. So if they get a major breakthrough in the same, and they could come with a this thing improved soil, then they cannot go for patent of the same, because the process is not patented. Process of agriculture, method of agriculture or horticulture is not patented, but agriculture equipments are patented. So if you remember, in one of the slide I shown you a machine which is used for, which is basically an agricultural equipment. So the equipments are protected as a patent, they are patentable in India, but the methods are not patented. The reason is very simple. Our economy is primarily agrarian economy. No doubt we are promoting the industries to a great extent. We have industrial revolution and all, but primarily our economy is agricultural economy. And if we say keep on granting patents in methods in case of agriculture or horticulture, then monopolies will be created in favor of certain people. And then again, there will be exploitation of others. And therefore, we don't grant patent in case of method of agriculture or horticulture. But equipment may we give patents. Moving to the next, like this I was referring to. I had little confusion there, but now it will be clear. So process for medicinal, surgical, like agriculture. Process for medicinal, surgical, curative, diagnostic, therapeutic treatment of human being or animals to make them disease free or to increase their economic value, that is not patented in India. For example, removal of a cancer tumor or removal of a this thing dental plaque or surgical processes, they are not patented. Method of vaccinations are also not patented. Blood transfusion methods are not patented. So the equipments are not, the processes are not patented. The methods are not patented. But what is patented? The products could be patented. So, like if you see in the end, the surgical or diagnostic apparatus or the instruments are patentable in India. So what is not patented? The methods or the process is not patented, but the equipments which are used in the surgery, like the stains which are used in case of a angioplasty, they are patented, but the process of angioplasty is not patented in India. Okay. Now this is very important for us as a student as well as faculty, that the literary, dramatic, musical, artistic work is not patented, but they are subject matter of copyright. So just because they are not patented, the literary, dramatic, musical work, they are not patented. That doesn't mean they are not having any intellectual property protection. They do have. So what kind of IP protection they have? They have. They are protected under the copyright law, and therefore they do not get patent protection. Then again, the scheme or rule or method of performing mental act or method of playing game, they are not patented in India. For example, method of solving crossword puzzle or learning a language. If someone has invented a very effective method of learning a language or teaching or learning process or a method, that is not patented. But any apparatus which is used for the same, for teaching, or if any apparatus is used for teaching a language, or if any apparatus is used for solving a crossword puzzle, then that is patented. So what is not patented? The scheme, method or the rule, they are not patented. They are, but the apparatus, the products which are used for the same could be patented. Now here again, the same could be, एक second. Sorry. I hope the screen is visible.
Yes, ma'am. Yes.
Ah. So the next non-patentable invention is where if there is any presentation of information, then that is again not patented. Just give me a minute. I'll just adjust the screen. There is some network disruption. Just a minute. Yes. So the scheme of presentation, the scheme of learning a language or crossword puzzle is not patented, but the apparatus products which are being used there are patented. Then the presentation of information. Like for example, for this lecture, for this session, I have prepared this PPT. So can I get a patent for the same? The answer is no. Because I'm just presenting the information, even though I might have designed the slide in a different manner. I may get a copyright for the same, but I will not get a patent for the same because it's just a presentation. So I'm not entitled for patent for the same. Then there are certain traditional knowledge elements which are again not patented in India. For example, the medicinal properties of neem, medicinal properties of haldi, or medicinal properties of certain other grains. They are not patented. It may be protected as traditional knowledge in India, but they are not entitled for the grant of patent. So, one example is noted here is the wound healing property of a haldi. So, we know that in every household in India, the turmeric is used for healing. Like even though you have like for small burn injuries or for small cut injuries, we use haldi. The same is not patented in India, but it could be protected as a traditional knowledge. Then the inventions which fall in the category of atomic energy, they are also not patented in India. Uh, because again the monopolies could be created, and further the government is having control over these products, and therefore they are not patented in India. Then the next part is how the patent or how you can obtain a patent. So here I have noted the process for the grant of patent in India. Even though there are 9-10 bullets, the process is very lengthy. Even though we are fast tracking the process of patent in last couple of years, the patent process actually takes a lot of time in India. Priyanka madam, whether the slide is visible on the screen?
Yes, ma'am, it's clearly visible.
Okay. I don't know. I'm not able to see the slide, so I was a little confused.
It's clearly visible, ma'am. You can move ahead here.
Okay. So, when you look at the procedure for the grant of patent, first you need to make an application. Now, application to be made to whom? The answer is very simple. You have to make an application to the Indian Patent Office. The next question is, who can make the application? Application should be made by the inventor. The first and foremost rule is application should be made by the inventor and inventor only. But there are certain circumstances in which other than the inventor, other persons can make an application. Like for example, the invention is, I am the inventor, but this invention is invented in the course of my employment. So I am an employee in a research lab, and there I have invented the product. So what we have to see? We have to see the terms of the employment. I might be the inventor, but the the rights with respect to the invention will be vested in the hands of the employer. So then the employer can make an application for the grant of patent. The third possibility is, third person who can apply for the grant of patent is person who is deceased. So a person has invented the invention, but he dies. Then his legal representative can apply for the grant of patent. So first and foremost rule is only inventor can apply for the grant of patent, but in certain circumstances, persons other than inventor can also apply for the grant of patent, like if it is in the employer-employee relationship or employment. And third is when there is the death of the person, then his legal representative can apply for the grant of application. Then you have to submit the application. So only these persons are allowed to submit the application to the patent office. So patent office ke pass you have submitted the application. Now that time, while submitting the application, you have to submit the prior art or novelty search report. So here I talked about the novelty, newness. The patented product or process should be new, not only within India but throughout the world. So you have to go through various databases of patents. So like Indian Patent Office has a database, and likewise other patent offices, they do have their own databases. And because of the reciprocal arrangements, we are entitled to access those databases. So you are actually supposed to go for the prior art search or novelty search, and that report is to be submitted along with your application. Now, what should be there in the application? So the details of the inventor. In addition to that, you have to describe the invention. So specifications of the invention should be there while drafting the patent. Now what is specification? Specification is nothing but the details of the invention should be there. So it could be complete specification or provisional specification. Generally what happens is, like when in terms of the technological advancements, various people may work on the similar invention. Some may get, or a person may get some breakthrough, initial breakthrough any person may get. So we are in a competitive era. In order to secure your patented rights, you have to make an application as soon as possible, and there you can apply for the grant of patent with provisional specification. Now provisional specification may, you have to briefly describe the patent. So where your final product is not ready, you are yet to go to achieve the final stage of the invention. Almost 80-90% work is completed. Then you can apply for the grant of patent with a provisional specification. And then within a period of 12 months, you can submit the complete specification. If you don't submit the complete specification within 12 months, then your application will be rejected or will stand abandoned by the patent office. So here we have to take lot of care. Also, you have to give information about your patents in other jurisdictions. Like I have applied for patent in America, in England, then details of those applications should also be submitted in this application itself. Because again, we have to see whether this invention is actually novel or not. What are the details of the other patent? So those details should be submitted in the specific in the patent application itself. Then you submit the application to the patent office. Patent office actually does a detailed scrutiny of this application, and then they will accept your application. So whatever the errors are there, they'll give you a chance to rectify those errors and all. Then your application will be submitted. Submission of application doesn't guarantee the patent. So once you submit the application, you have to go for publication. So publication ka request should be made by the applicant himself. So publication ka request you should make after the publication is open. After your request of publication, the Indian Patent Office will publish the invention along with all the documents on their official website, that is IP India ka website. All the details of the application will be there along with the details of inventor, then employer and all. So those details will be there along with all the necessary documents submitted. Then you have to make an application request for the examination. So again, examination will not be conducted by the patent office on its own. the request of examination should be made by the applicant only. So make a request for the examination. Now, who conducts the examination? Examination is conducted by the person skilled in the art. So they look for the inventive step. They look for the non-obviousness of the invention. As I told you earlier, when it comes to the assessment of inventive step or non-obviousness, it should be done by the person skilled in the art. So Indian Patent Office has a pool of examiner who are skilled in the art. So if the invention is with respect to chemistry, it will be sent to the scientist in the same field. If it is related to physics or any other discipline, biotech invention, if it is, then it will be sent to the examiner who is skilled in the specific subject. So after the examination ka report comes in, again it will be published on the website, and then the application will be open for the oppositions. So any person may submit the file an opposition to the grant of patent. There are various grounds for the submission for the opposition, which includes the details given in the application are misleading. The inventor's details are not clearly given. Pre-grant opposition may also be filed for non-obviousness not being there, or if the industrial utility is absent, or the novelty ka threshold is not met, if the information about the foreign applications is not submitted. On those grounds, the pre-grant opposition may be submitted by any interested person. Once the pre-grant oppositions are there, then obviously the copy of the same will be given to the applicant. The applicant will be given a chance to respond to these objections which are raised by any person. And any person here actually means any person. So if you go to IP India's website and if you want to file any application, any opposition, then the same can be done by any interested person, but you need to justify your claim or objection. Then the applicant will be given a chance to submit his responses to the objections or oppositions which are made. Now here there are three possibilities. The submissions which are made or responses which are submitted by the applicant will be rejected in total. So if they are rejected, it means the application for the grant of patent is rejected, it is abandoned. Second possibility is these responses of the applicant will be accepted as it is. Then necessarily it will be considered as acceptance of the application. Thirdly, the Indian Patent Office may also suggest certain amendments or modifications to the application. So the inventor or the applicant has to make those necessary corrections, amendments in the application, and has to submit the revised application to the patent. Case where the application there were two inventors working on the same invention, and one person applied for the grant of patent without the knowledge of the other inventor. So let's take an example of A and B. A applied for the invention, and he didn't inform about the same to B. Actually, both of them were involved in the patent process since day one, but in the invention, the research and all, they were involved since day one, but without the knowledge of B, A applied for the patent. So when the application after the examination, when the application was open for oppositions, for inviting oppositions, objections, then B got to know about the same from the Indian Patent Office. So he raised the objection. Now here, the Indian Patent Office suggested that instead of asked A, if you want to, since it's a misleading the invention, misleading application because details of the other inventor was not given. So the choice was given to A, you can withdraw the application. We will reject the application if it is not withdrawn. Or second option is include B's name as a inventor along with your name. So A decided to accept the second option because anyways it was misleading information, so his application was bound to be rejected. So he took the second option and he submitted the revised application. Now initially there was only one inventor, now we have two inventors, so the details of the second inventor were added. So this is very basic change in the application. Other example is where in the third stage here, I told you about describing the invention. So in the detail description, some elements were missing and that was brought to the notice of the patent office during the opposition proceeding. So again here also the inventor was given a chance to modify the application. So after that, revised application was submitted. So the responses are to be given to the objections by the concerned person within the given time, and after that, the patent will be granted. Now, patent will be granted means what? The details of the invention along with the details of the inventor will be entered in the register of the patents, which is maintained by the Indian Patent Office. So IPO, Indian Patent Office, is very particular in detail in including these details in their register. So these details will be entered and the copy of registration certificate will be given to the patentee. Now the applicant becomes a patentee, so he'll get the copy of the registration certificate. So grant certificate ka copy he will get. Now once there is grant of patent or the patent is registered, does that mean you have exclusive right over the patent? Again, the answer is no. There are two things. The one is with respect to compulsory license that I'll come to in a while, but post grant opposition. So post grant opposition is where the granted patent will be open for post grant opposition by any interested person for a period of 1 year from the date of grant of patent. Now, again, here there might be some revisions in the patent application as well as people may have certain objections like with respect to date of application and all. So those details, those things will be brought to the, you can always bring this to the notice of the patent office. The grounds for the pre-grant opposition and post-grant opposition are similar. The only difference is post-grant opposition should be submitted by any interested person within a year from the date of grant of patent. So this we need to take care of. Second. Before going here, I have missed the slide of compulsory licensing. Now you have obtained a patent. Does that mean you can use the patent for commercial purposes? The answer is yes, because as a patentee, you are entitled for the same. It's a right of a patent. Now, patentee has certain rights. One is using the patent for the commercial purposes. He can surrender the patent, and we have various examples where the patents have been surrendered. So people are not really very keen on accumulating the wealth against the patented product. Instead of that, they consider giving this patent to the world at large. If you take Covaxin ka case, it is a patented invention. And again, other fact of Covaxin patent is it is one of the fast-track patented case of India. The patent was granted within a short span of 6 months in case of Covaxin. So, a lot of exemptions were granted during the grant of patent in case of Covaxin. But obviously, that was the need of the time. Now, here, when you have a patent, the first and foremost right is you are entitled to use the patent. You can surrender the patent. You can give licenses of the patent to any other person who is interested. Also, you have every right to file a suit of infringement when there is unauthorized use of a patent by any person. So there are two possibilities. Either the person is unauthorized, like license is given to Mr. A, but instead of that, Mr. B is using the patent. So its person is unauthorized. That amounts to infringement. Or ACO license is given. I have given license to A only for the manufacture of the product, not for the sale or marketing. Sale and marketing is with someone else. So what A has done, A is not only manufacturing the product, but he is going for sale as well as marketing. So that is also unauthorized use of the product. So then both are considered as infringement, instances of infringement of patent, and then person has every right, person in a sense, patentee has every right to file a suit of infringement against that person. Now, when you file a suit for infringement, you are entitled for three remedies. The first one is injunction. I'll just briefly explain these remedies and then I'll come to compulsory license wala part. You have three remedies. The first one is injunction, where you can prohibit, you can stop the other person from using the patent, because either the use is unauthorized or the person is unauthorized. So you can stop the person from using the patent. Second one is you can ask for damages. Now, damages may you ask for whatever losses are incurred upon you. Whatever losses are incurred upon you, those losses can be recovered from the patent, from the infringer. And thirdly, whatever profits are earned by the person who has infringed your patent, those profits you can ask through account of profit. So generally, these three remedies are granted by the court. So the suit is filed generally in the district court for the infringement. So what remedies are available? Three remedies. Injunction is there, where you actually stop the person from using the patent. Second is where you can ask for the damages which are incurred to you. And thirdly, you can ask for the account of profit, where profits which are earned by the other party, you can ask for those profits. Coming to the last point, that is compulsory license. I am very sorry, I have missed the slide in the this thing in the presentation. Compulsory license. Now, see, in the initial discussion itself, I talked about the purpose of the grant of patent is not only for the monetary profit of one particular person. It is also for the benefit of the society at large. Okay. Now take a case of Covaxin. Now Covaxin is invented, it is patented. What if I have the right to sell the Covaxin, and during the time of COVID, consider this. We have seen, like in some case, some medicines, how there was hoarding of the medicines and how black marketing of the medicine was there. So here I am selling the Covaxin, and one vial of the same is costing, or one dose of the same is costing 2000 rupees. And I have to take, say, 3 vaccines or 2 vaccines. Now, is it affordable? The answer is very clear. Then in that case, like what the patent office has done, or what the Indian patent law has done, that when the patent is granted, the grant of patent automatically put certain restrictions on the patentee. And one of the restriction is making the patent available to the public at reasonable prices and in a reasonable quantity. Reasonable prices, or rather reasonable requirements of the public are to be satisfied. Now, what reasonable requirements? The pricing should be reasonable, and the quantity in which the product is made available, it should also be reasonable. Now, I'll tell you one case law. It is Natco versus Bayer. It's a very famous case law in India. And the facts of the case are very simple. And even though you may not be a law student, you can easily understand the same. So, what happened here is this Bayer is both Natco as well as Bayer are the medicine companies. Now, Bayer is a foreign player, foreign multinational company, and Natco is a Indian Indian medicine company. So, Bayer has invented a medicine to treat the cancer patients, and the cost of the drug is 80,000 rupees. So, a person who want to avail this drug, he has to spend 80,000 rupees per month. Now, Natco worked on the same medicine, and this came up. They approached the Bayer, and they said that we can manufacture the same medicine for 8,000 rupees per month. So the cost will be, now you can see how the cost element is reduced. So 80,000 one hand and 8,000 per month. So there is a huge difference in the cost. So obviously, Bayer refused this proposal because obviously the number of cancer patients are increasing. So dependency of the people on the medicine is also higher, and it's a very good opportunity to create wealth. So Bayer refused to do so. So NATCO approached the Indian Patent Office and asked for compulsory license. Now this compulsory license is a very important term from the Indian Patent Office, where if in these circumstances, like when the reasonable requirements of the public are not satisfied, then compulsory license may be granted. So here actually the compulsory license was granted by the Indian Patent Office in favor of NATCO. Then again, this case was challenged before the court, the Indian Patent Office, and then before the Indian Intellectual Property Appellate Board. Now this Intellectual Property Appellate Board is discarded. Then it went to Chennai High Court and finally the Supreme Court. If you see the judgment of the Intellectual Property Appellate Board, it very specifically analyzes that how the patents are granted for the welfare of the public at large. And considering the medicinal uses of the same, like on one hand, the number of cancer patients are increasing. So it is very apt to give compulsory license. So voluntary license ke liye there was an effort. So the company was not ready to give voluntary license. So compulsory licensing was granted by the court, and that is how this medicine was made available to the public at large. Okay, so this is largely about the patent law. I have tried to cover almost every aspect. Coming to the last one, how can you contribute to IP? There are only four things which we can do, which we should do as a student, as a faculty. We need to be innovative. Now, one example is ChatGPT. We every now and then we rely on ChatGPT. Instead of that, be innovative. Use your own brain. Use your own intellectual capacity to create the work. Think outside the box. Don't go like you should not be driven away by whatever is there in the public domain. You can always apply your mind and think something innovative. Instead of buying fake products, insist for the original product and produce the original work. Like a lot of us are involved in writing the research papers. Students are involved in writing their dissertations or their assignments. Try to produce the original work. Try to read and apply your mind. Create the original work. And that is how, don't buy fake products. When you buy fake product, then obviously it's a damage to the economic rights of the owner of the product. So instead of buying fake, try to buy the original products, try to produce the original work is what I can say and tell to all of you. With this, I'll conclude and I will be open for any question answer.
Yes, ma'am. Thank you, ma'am. Thank you so much. I would now like to request to participants, if there are questions, please go ahead and ask ma'am. If it is not possible to ask through audio, you can just put the question in chat box.
Yeah, I am accessing the chat box also.
Yes, yes. There are so many participants, ma'am. Since morning, there are this participants list is complete, full. 100 people are there, but still, why don't I don't know.
Yes.
There is a question,
There
ma'am.
is a question, yeah.
Ma'am,
Any government bodies we can approach for patent? Yes, we do have the Indian Patent Office, and they're very approachable, and you don't need to approach them physically. They're available via email also. Their services are available via email. You can just go through their this thing website, get the email ID, put your query. They're very prompt also. Indian Patent Office. Yes, ma'am. You can avail the services through Indian Patent Office. But for applying for the grant of patent, you have to take help of any patent agent. I couldn't get what is BCP.
Can you just
Patent
elaborate what is BCP?
Yeah. Yes, somebody is asking about the doubts. Yes, you can ask your, if you go to their this thing, website, they have FAQs, list of FAQs is there. And still, if you're not satisfied with the same, then you can go for this thing. Like you can write a mail to them, they will respond to your query immediately. With respect to business continuity planning, then that could be protected under the this thing, copyright law. The business models are protected under the copyright law. Patent agent, there is no specific websites, but if they're like patent agents for that, you can approach the Indian Patent Office. They can provide you the list of patent agents.
Ma'am, it is BCP's full form. They have said business
Yeah,
continuity
I
planning.
told business continuity
Okay,
planning.
yeah,
So
okay,
business continuity planning, my business model, if it is there, na, then you can apply for it. The copyright law will be applicable. The patent law will not.
So is there any other question from your side? I think there is no more, or there are no more questions, ma'am.
Yes.
Even I would like to ask something, ma'am. It's regarding copyright, actually.
Yes.
One of the, in the previous PPT, Kamani sir has mentioned that copyright was regarding the article or research paper that you published. That also can be copyrighted. So can you just give some kind of light on that?
So it's
What is
very
that?
simple. So the moment you write the article, you are the owner of the copyright because of the author. So author is the first owner of the copyright in the copyright law. So the moment you write, you are the owner of the copyright. But what happens is when it is given for the publication, they generally takes one kind of undertaking from us, assignment, where we say that the copyright of this article rests with the publisher. There we assign our copyright to the publisher.
Yes, yes.
So then the publisher will be the owner of the copy. So because of the assignment, it's a transfer. There will be a transfer. But the principal rule is the one who creates the work, the one
Yes.
who writes the work is the owner of the copyright. But because of this, we assign the work to
Publisher.
not work. We assign the copyright. So if it is this thing, and what happens is, take example of a edited book. Journal may be there may not be many subscriptions, but edited book may you are contributing as a author. The book is published. Now the publisher, the editor and the publisher, or maybe the publisher or the editor, they'll earn.
Yes.
Do you get any royalty there? The answer is no, because we signed that undertaking that we are giving away or we are transferring the copyright to the editor or to the publisher.
Yes.
So if you want to retain the copyright, you can do so by just not signing that undertaking. But if you do so, then you are losing the copyright. Also, many of us have completed our PhDs. Correct. So who owns the copyright in the PhD? Is it the research scholar? Guide ka to obviously no question. Or the university? The answer is university. Because it is written in the law that when the thesis is written, or in case of dissertation also, the concerned authority will have the copyright. And that is why if you want to convert your thesis into a book, you require prior approval of the university. Without that, if you do, then obviously university will have a right to file a suit of infringement against you.
Okay. Are there any other questions? I think it's time to conclude, ma'am. Ma'am, you have talked on IPR in depth today, actually, and with respect to patents as such, there were a lot of questions in our mind, and it was almost we have a clear idea right now how to file the patents and how to get that awarded till the award process. So you talked about patent process products not only cover patented but also what is not to be patented also. So with examples, you have elaborated this patents process. So thank you, ma'am. And I would like to now request Dr. Sunanda Vagmare, ma'am, to please address us as a chairperson with her views and guidance.
Thank you, Priyanka ma'am. Thank you, Dr. Suvarna Nilak ma'am, for that very clear and helpful presentation. Ma'am, you have made the complex topic of patent and technology transfer very easy for us to understand. You have helped us to understand how innovation and patent work non-patentable invention in very simple way. It is now how much easier for us to see how researcher in our college can be protected and shared with the words through technology transfer. Ma'am, you gave us many examples to understand how patent work. We discussed why new ideas are important for progress. We learned that patent and non-patentable inventions are essential to protect a researcher's work. We understood the procedure and stages of obtain a patent. Once again, thank you, Dr. Suvarna Nilak ma'am, for such an enlightening session. I want to thank all participants for their attention and for the questions they shared. I am sure everyone found this session very useful for their future research and academic work. With these words, I conclude technical session 1. Thank you, everyone.
Thank you, ma'am. Thank you
Sunanda ma'am.
once
Thank you,
again for
Priyanka
that.
ma'am. Thank
Yes,
you.
ma'am.
Nice to meet you. Thank you.
Yeah, nice
Thank
to
you.
meet you, ma'am. Actually, it was a very wonderful session. All the questions were solved from our side. So thank you once again, ma'am, and thank you, Sunanda ma'am, for chairing the session. So,
Thank you.
dear participants, will move towards the next session within 2 minutes.
I can leave the meet,
tuned.
right?
Yes, ma'am. Yes.
Okay. Thank you.
Yeah. Prahlad sir, have you joined? Jadhav sir? So, welcome to you to the last session of this IPR National Online Seminar. We'll move toward this last session, in which we have resource person Mr. Prahlad Jadhav sir. I'll take this opportunity to introduce him. His biodata itself speaks a lot. It's very huge, but I'll just try to make it short. So, Mr. Prahlad Jadhav sir is seasoned library and knowledge management professional with over 20 years of experience across corporate firms, universities, and academic institutions. He has been serving as an associate director library at Khaitan and Company since 2006, contributing strategically to knowledge services in a leading corporate legal environment. He is UGC NET qualified in Library and Information Science and holds a master degree from the University of Mumbai with second rank. Along with PGD LIM from TIS and Certification in Intellectual Property Rights, Mr. Zadhav has delivered 225 plus lectures. So we can imagine his area of this IPR and his knowledge regarding this. So he has delivered almost about 200 lectures on this topic in even UGC, HRDC centers, universities, government departments, and corporate platforms, addressing faculty members, professionals, and students. He has also presented 25 research papers at national and international conferences and has received the Best Paper Award twice. Mr. Zadhav has received several prestigious national awards, including the PWD Icon Award, Social Impact and Excellence in Corporate Networking Award, India's 50 Eminent Libraries Recognition, Dynamic Librarian Award, and the Shri Sukhadev Singh Award also. So he also is actively contributing to the academic governance as an IQAC external expert, Board of Studies member, guest faculty, and external examiner also. His core expertise includes AI in teaching, AI in teaching in libraries, copyright and plagiarism, cyber laws, etc. Knowledge management, retrieval strategies also. So this is the core area where he talks on. And Mr. Zadhav has received several prestigious national awards, including the which I have already said, that India's 50 Eminent Libraries Recognition, and everything is on his name. So I wholeheartedly welcome you, sir, and request you to kindly guide us with your insights broadly on the copyright and plagiarism aspects in IPR. Over to you, Zadhav, sir. Hello, sir. Zadhav, sir. Sir, mute कराओ. Sir, तुम्ही बंद. Sir, kindly unmute your from your side, sir, please. It's muted. Hello. We can't hear you, Zadhav, sir. Sir, आम्हाला mute करा ना. We'll just wait for 2 minutes. He's joining. Sir, you are joined there, but your mic is not working actually. Please select the mic which are. Hello, Dadav sir. We'll just wait for 3 to 4 minutes more as he joining from the another device. Stay tuned till then.
हेलो हेलो माझा आवाज येतोय मॅडम हॅलो
Yes, sir, you're audible now. Yes.
ओके ऍक्च्युअली there's a speaker issue with my laptop, so I had connected now the external.
Yes. That is okay, sir. That is okay. You can start now.
So yeah, just give me 1 second only, please. Yeah. So first of all, I would like to thanks the management of the college, Shri Shahu Mandir Mahavidyalaya Pune. I really want to, mention a special appreciation to the management for selecting the topic IPR, which is a much needed topic in today's era for the not only for the students, but even for the teaching faculty, which is really important. And I was there since 10:30, and I was listening the other speaker, Dr. Suvarna. She was explaining each and every aspects of the patent very well. So thanks to her also, and thanks to Priyanka ma'am for giving this me opportunity to talk on one of my favorite topic, that is copyright. So I'll start with my presentation. Just allow me 1 second.
Yes, sir.
Yeah, please confirm anyone whether it is visible to you.
Yes, sir. It is visible. You can start.
Thank you, thank you, thank you, thank you. So we are going to touch many aspects in this IPR workshop. Basically, the topic which you had given to me, it is thoroughly, related to the literary work, which is really important in today's area. So I'm going to talk about some part of the copyrights plus how it will reflect with the academic publication. Second thing, the IPR role in the higher education and research ethics. So I'll try to cover maximum points which I have, or explore in my career, in my working experience as I'm working with the law firm. So one of the important advantage for me is to explore IPR in a very detailed way. So I started my career in 2009 when I was selected in one of the topmost law firm in India, that is called this Ketan and Company. It's a law firm, and there I got an opportunity to work with the lawyers, and from there the interest generated. So anyone from the academic fraternity can raise the question how a librarian can very much interested in the IPR. This is the reason because my work profile deals with them. I'm regularly working with the lawyers, attorneys, agents, copyright writers. See how their problem can be, how their research can be resolved. So I'm working with the library as associate director with a team of 19 people, and on a day-to-day basis we are getting such type of requests. So when you ask any librarian, can you give me full book of PDF? The important answer from him, no copyright. So user आपको बोल देंगे just WhatsApp कर दो ना. It is not like it is not that easy. Many times, even for us, if you go to the high courts or the supreme courts, when we are giving them a copy from the third party databases, they just reject it. They want the true copy from the database which had mentioned by the government, for example supreme court. So we have to submit the same day. We have to give value to the literary work, otherwise it will be very difficult when you find it ki array your work, but the credit is not given to you, your work it is used for the commercial, at that time then the pain will be there. So it is better you have to play with the safe and with proper protection to your work. So why on 23rd April we celebrate Copyright Day, as I'm going to more focus on the copyright. So why we celebrate Copyright Day on the 23rd April? It is a tribute to a literary vision. April 23rd is a symbolic link to the death anniversary of two famous great writers in history. Who are they? William Shakespeare and Miguel de Cervantes. Both are considered, yes, they are considered as the pillar of world literature. So this date become a very important and powerful symbol to honor these authors and creativity. That's why we celebrated 23rd April as a copyright day. So there is a just a fun fact for you. Hello, hello, hello.
Yes, sir.
Hello.
You are audible. Is there anybody who is
Okay,
disturbing? Please keep your mics mute so you can continue.
okay, okay. Thank you. So just a fun part. When student and teacher was going to converse, teacher to student, kid, your essay on my dog is exactly the same as your brother. Did you copy from him? Student, no teacher, it is about the same dog. So this is the conditions. When you copy, you have to, बोलते ना, in Hindi there is a कहावत, नकल में भी अकल की जरूरत होती है. The same way it applies when you are copying something, but you are just presenting your own idea. That is wrong. So how we have to go, how we have to present, how we have to give the site, how we have to give the credit, or if you are dealing with the commercial work also, how we have to deal. So overall, what type of safest way we have, I'll just go through that. So suppose early in the morning, if I'm going to our office, I'll take my bicycle and I lock it. Why I lock it? See, if you're careless, your work will be stolen. The same thing for the things. If you're careless, your things can be stolen. So intellectual property will protect your intellectual creations against the theft, right? So this is the one of the BOD meeting is going on there. Board of Directors meeting is going on, and another director is explaining the P&L account to other directors, and he had mentioned that there is a gap, there is a blank. That blank is taken by other director who was with us earlier, but with his creation, with his IPR, he had taken that blank. It means your IPR is a long-term investment. For example, if you patent something, if you cooperate something, you will get the royalty for lifelong, for lifelong and long term. That is the importance of that. So you have to be use it very well, very effectively. Then only your work can get credit. Otherwise, it will be difficult. It was a same for you or for me also in the school days. Best memory of our school life. What is that? Best memory of our school life? Notes copy करते समय. I was asking my friend. No, I was copying the notes. ये क्या लिखा है बे? The answer he replies to me. जो समझ में आ रहा है वो लिख बाकी ऐसे ही डिजाइन बना दे. The same mistake we do. We just copy it. We never think here we are copying, but we have to give at least the angle in a different way. At least the synonyms in the different way. But no, we are just copying it, so which is not effective. IPR play a very important role from when you begin your a day journey since morning to the end of the day. So you can imagine with this dag अच्छे हैं, it is very easy. What is that? Surf Excel. जिंदगी के साथ भी जिंदगी के बाद भी. What is that? LIC. हक से मांगो प्रिया गोल्ड. इसको लगा डाला लाइफ जिंगा डाला टाटा स्काई. So this is the impact of IPR on your day-to-day life. It means when you start your day with a brush, with a Colgate, with a soap, since then you're going to the good night. All are connected and all are protected with the help of IPR. And it has created a goodwill for the product. Not only product, your work will get a recognition. Without that, it will be difficult. So it is not only role of your higher authorities or government agency. It is your own role. If you are creating something intellectual, you have to protect. Otherwise, it can be stolen. So the assets can be divided into two types. What are they? Tangible assets and intangible assets. As most of the commerce students are known this, right? So these are some of the fixed assets. Tangible assets, I can explain you: cash, equipment, machinery, physical plant, property, inventory. This can be seen. But when there is a goodwill, it can be visible. But it is a very valuable. So that's why IPR play a very important role. IPR have two branches, basically the industrial properties and the another one is copyright. The other things are covered by my other colleagues. What are the industrial properties? For example, trademark is there, patent is there, geographical indication is there, plant variety is there. Many of them are. But I will take considering the major part of the copyrights and other relating rights. So we'll just go in a depth. So these are the branches: IPR, patents, trademarks, copyright, industrial design, plant variety, trade secrets, layout designs of IC, geographical indication. So you might know each and everything, but I just want to highlight here the copyright and which is related for me for this session. That is another part of the regulation that is called plagiarism. I'll go in detail once we go there. So why IPR is important? We are just making a background of the copyright, why IPR and copyright, how it is connected. So see the basic example of tide and tides. The one is original, left hand side is the original, right hand side is the duplicate. The another one is Puma and duplicate Ruma. So this we can easily identify. What we identify? We can identify original and duplicate. That's why IPR is very important. IPR theft, yes, it is possible, and it is a very casual way your IPR can be theft. I'll just give an example. Engineer regularly had a lunch with a former boss. He's thinking that I'm having a pleasure, I'm having a lunch with my boss, but he was thinking that he is a hero of gathering competitive intelligence. But the information he was giving to his boss, earlier boss, ex-boss, they lose the three significant bits in a couple of months. So in a very casual talk, we can lose your intellectual. So you have to be very careful when you're detailing anything, when you're discussing anything, when you're sharing anything. At that time, you have to be very careful what you're going to talk, what you are sharing. You have to be, we have to be identified. You have to be get recognized. कि बाबा मैं ये जो चीज share कर रहा हूँ, whatever I'm sharing, whether it is useful for her or not, for that person or not. So be careful in sharing the things. Another way of IPR theft, the immigrant scientists from European countries, they got unsolicited invitation from their own home countries to come and speak on different seminars, and they serve as a paid consultant. The country saw this kind of intelligence gathering as cheaper than such research and development. Why they are calling? They are getting the information, they are getting the intellectual. Why these countries are investing on them? Because they are considering gathering such intelligence is as cheaper than investing on the R&D, that is research and development. So this symbol, whenever you see, it is a copyright symbol. This copyright sign is copyrighted. Please do not steal it. And whenever we see, we get a little alert. Arey Baba, ye copyright. We have not to copy. So that's why that work is protected. So there is a very short story. Mr. Y, an artist, is decided to make a short film. He has a very good story. He made the film. The film is based on the swag, Indian swag. So he added a song called Swag Se Karenge Sabka Swagat. But while uploading the film, he received a threat, copyright infringement strike. You can't add this song because it is already copyrighted in another film. So this is the way your intellectual can be protected. So at world level, who is going to organize, who is going to take care of all these corporate laws, regulations, your treaty? So WIPO, World Intellectual Property Organization, is taking care of that, and they are playing a very important role, not in only in terms of protecting, but they are also, upgrading the young generation, updating the young generation. What, how you can, give importance to that, how important your IPR, how important your copyright. So they are making awareness of all these things to the young generation. And with the help of such seminars, it is again a role or duty of the higher education institute. They can create awareness among the students and the teaching faculties. So in copyright, there are two important convention. Sorry. So first one is Paris Convention for the Protection of IP, 1883. It was passed in 1883, right? And the second one is that is called Berne Convention. See, Paris Convention is specifically for the intellectual property. But if you ask me for the Berne Convention, which was passed in 1886, it is purely for a protection of literary and artistic work. This convention is deal with the literary of how a can protect the literary and artistic work. So that's why if you talked about the copyright at that time, this Berne Convention is very important. Then protection of IPR, why we have to protect? There may be any number of reasons, but I want to highlight here a couple of reasons. for the progress and well-being of the humanity. Of course, for the progress and the well-being of the humanity, you have to protect the copyright, right? Then protect the IPR. Hope you had saw that the Dakka movie, right? In that, that Makran Anaspuri had invented something, but he doesn't have the knowledge of IPR, so he didn't protect it. But his brother-in-law protected. At that time, the protection become a very critical for the Makran Anaspuri because he got the chance to oppose the company which was using his intellectual, his creation without any notification. Then legal protection of new creations. Yes, of course, there is requirement of a legal protection of the new creation. So that's why protection of IPR is important. And economic growth creates new jobs and industries. These are the importance of IPR. And every stakeholder in the country, those who are related with this IPR, they have to create awareness and they have to protect. So copyright is an intellectual property, right? Which is definitely in exclusive right for the creator of what literary, musical, and other artistic works, which may include films, sound recording, computer, software, etc. So this is where copyright applies its right. Okay. So copyright provides the legal framework. To whom it provides the legal framework for the protection of traditional beneficiary of copyright? It might be individual, author, composer, or artist. Moreover, also for the investment required for the creation of works by major cultural and other industries. So that's why copyrights provide you the legal framework for individual author, composer, or artist, and also to whom those who are making investment which is required for the creation of works. So for that investor also it gives you the legal framework. So what type of works protect in the copyright? That is really important. So literary work, yes. Painting, yes. Photograph, yes. Drawing, yes. Films, yes. Music, choreography, sculpture, yes. So all these eight type of different works are covered, are protected by the copyright law. So what is literary work? School textbook, dictionary, novels, then newspaper article, question paper, computer program, and database, right? Judgment or order of a court exempted in the literary work. However, the headnotes provided in the commentaries, they are protected. Right? Who is the author? The writer who write the books, who write the dictionary, who edit the novels, who compile the dictionary, who publish the newspaper article. They are the writer or the owner. And the term of copyright, lifetime of author plus 60 years. It means जब तक वो जिंदा है उसके बाद और 60 साल. Lifetime of author plus 60 years. The second work, dramatic work. Example of dramatic work, drama, play, any piece of narration, entertainment in dumb show, choreography, etc. Excludes the films is excluded. It is recording of dramatic work and it is not dramatic work itself. Who is the owner? Creator of the work. Then what is the life term of the copyright? Lifetime of author plus 60 years. In this also lifetime plus 60 years. Then musical work. It means the work consists of music and includes any graphical notation of such work. The song is not a musical work. So who is the owner in this category? The creator of the music. Yes. And the term is lifetime of author plus 60 years. In this case also the same. Sorry. The next one is artistic work. A painting is a painting, a sculpture or drawing, a diagram, map, chart or plan. Right? Image or a photograph. Work of architecture means what? Building or structure having an artistic character of design or any model for such building or structure and work of artistic craftsmanship, hand knitted wooden sweaters, handicrafts, the range of pottery, etc. Modern furniture is not an artistic work; it is a design. Then in this creator, who is the owner? Creator of the music. Sorry, creator of that work. And what are the term of copyright? Lifetime of author plus 60 years. Right? In majority case, the same. In sound recording means a recording of sound on any medium for which sounds may produce. Producer of the work is the author, and the term of copyright 60 years from the year subsequent to year of publication of the sound recording. When it is published from that 60 years. So in this category, it has changed. Who is the author? Producer. Term kitna hai? 60 years from its publication. Film, example films, animation film, video films. Producer of the work, the same 60 years from the year subsequent to the year of publication of the film. From the publication from that 60 years, the copyright period is on. Then broadcasting reproduction rights. Broadcasting means communication to the public by wireless diffusion or by wires or any form of signal, sounds or visual images. Author broadcasting organization. Term 25 years from the year of broadcast. जब से broadcast हुआ वहां से 25 years तक. For example, MPL, IPL, MPL matches. Performer right, performance of actor, musician, jugglers, acrobat, a person delivering lecture, snakes, charmer, and dancer. Author, performer of the work. Term of copyright, 50 years from the year of performance. So this is the different types of acts can be covered in the Copyright Act. Who is the owner of the copyright? Generally, the owner is the author of the work or the writer, composer, artist, producer, performer. In this, the owner, what type of rights they have? They have two types of rights. One is economic rights and another one is moral rights. So, moral rights, attribution, integrity, and reputation. In short, to claim the authorship. In short, to restrain or claim damages in terms of in respect of misrepresentation. Economic for to reproduce the work, to issue copy, to make any adaptation or to translate the work. These are the rights. There are two types of rights. One is moral and another is economic. Right. So infringement, it is derived from the word infringe, which means break a law or an agreement. It leads to economic loss to the owner of copyright. Of course, किसी ने किसी का copyright work को अगर कहीं पे commercially publish किया है, then definitely there will be economic loss to that owner of the copyright. Second one, beside economic loss, it is also adversely affects creativity. Section 51 of the Copyright Act 1957, which defines the copyright infringement. Okay. If any person without permission or license from the owner or registrar or in contravention of law does any following act will cause infringement. It includes where infringement it implies to sell, hire, offer to sell or hire, distribute copies for commercial purpose, exhibits in public, imported into Indian any infringing copy. These all are covered in the infringement. So whenever such things are happened, infringements, copyright infringement is there. So fair use and the public domain. In copyright, these two important concepts are very important. I'll explain one of them one by one. The fair use versus public domain. Work used under fair use are still copyright material. The work in the public domain are not covered by the copyright. Parts of work may be only used for education, research, news reporting, criticism, or parody. In fair use, only parts can be used. In public domain, allow entire work to be changed, adapted to either other media or reproduced with no legal consequences. Permission needed to be obtained to sell or distribute the online work. Yes, in fair use, permission is required to obtain or to sell or distribute the entire work. In public domain, there is no require of permission. You can do it directly. In fair use, you have to give the credit to the original creator. In public domain, it must be given to the original creator by citing the source. That is the only thing. So when you talk about the fair use and public domain, these are the two rambans which will help you to don't get into stuck in the copyright angle. So Copyright Act 1957, it is a very old act which came effect from January 1958. The act has been amended 5 times: 83, 84, 94, 99, and 2012. 2012 amendment was a very important and crucial. So we'll just check one by one. In 83, it is amended due to broadcasting technology and reprographic technology. In 1984, due to technology like printing and recording, it is amended. In 1994, due to the piracy of medical textbook, it is amended. And in 1999, confront of the trade aspect, it is amended. But as I told you, the Copyright Amendment Bill 2012, which was passed on 8 June 2012, 8 June 2012, Copyright Amendment Act is significant in terms of challenges posed by the internet. So that is the reason it is very crucial and important. Also, it is very important for the academic and the teaching faculty. Why it is important, I'll let you know. In this, there's a commercial rental agreement. Yes, rental commercial rental amendment in the section 2 after clause F. There is an insertion of FA, commercial rental. Commercial rental referring to the cinematography film which includes rental, lease, or lending of a lawful copy, acquired copy of a computer program, sound recording, visual recording, or film is made by a non-profit library or non-profit educational institute. So in this case, that institute or organization can give that on a rental, lease, or lending. I told you it is very important for the teaching faculty because of this. Section 52 of the Act. Yes, my dear friends, Section 52 of the Act. These are properly known as a fair use clause. Literary, dramatic, music, or artistic work. Now, it covers all works except software. It in effect covering sound recordings and video. Copies of songs and films or research to use films, clips in classroom, etc. Even I can use film class clips in the classroom, etc. under the banner of fair use. Sorry. So why it is important? Why fair is important? So there is amendment in the general context, subsection 1, clause A, a fair dealing with any work not being computer program for the purpose of. When you use that work for this reason, then only it can be covered in the fair use. Research, criticism or review, reporting of current events and current affairs. Storing of any work or work in the electronic media for the purpose mentioned in those clause are can be termed as a fair use. So another important amendment in this digital work, electronic transmission of communication allowed, subsection 1, clause B. Electronic link, access or integration can be allowed in subsection 1, clause C. So digital work can be communicated, can be give access, but with this help, with this amendment. Suppose if you got the notice regarding the infringement in this fair use clause or in this section 52, the new clause is added, that new clause C of section 52. If you got the notice, you have to, if you got the notice in written complaint, you have to remove that. You have to remove further still order you received. If you don't receive any complaint, any written complaint, then you can carry on. But if you received any complaint or written complaint at that time, you have to withdraw that. Judicial proceeding, subsection 1, clause D. The reproduction of any work for the purpose of judicial proceeding and report of a judicial proceeding. Education institution activities, subsection 1, clause J. The performance in the course of activities of an educational institute. It means what? Judicial proceedings are exempted. You can make copies under the fair use clause for the court purpose, for the for the argument purpose, or with the counsel. You can do it. Same way for the education institution activities, subsection 1, clause J, it is applied. Digitization of library, subsection 1, clause N. Yes, public library to store an electronic copy of a work if it is already have a physical copy of the work. Storage shall be specifically for the preservation purpose. Then it is allowed. Technical drawing, yes, allowed. Engineering to mechanical device, subsection 1, clause W will allow you to that conversion. Making three-dimensional object to the two-dimensional object, technical drawing, yes, of course, it is allowed under the fair use clause. This is something new. Fair use rights, yes. In for the disabled people, new clause ZB has been added to the section 52, subsection 1. It provides what it provides to the organization or institutes. You can adapt, reproduce any accessible format to facilitate person with disability. It is mainly for education purpose or research. These rights are available to any person or organization who are working for the benefit of the person with disability. See, it is very important for the academic purpose. For any disabled people, you can convert or you can adapt it. Again, a new section 31B has been introduced to provide a compulsory license in the work for the benefit of the disabled. If any organization is working for the benefit of the disabled people, at that time a compulsory license is required to take it. Otherwise, it will be creating a problem. So, if you're working towards the benefit of the academic disabled people, you have to have a compulsory license. Insertion of new technology 65B. This is for remove or alter any rights management information without authority. That is called DRM, Digital Rights Management. So if you're moving any digital right information from that product or anything, it is definitely infringement. So you have to take the approval. There are certain worrisome changes is there in the amendment. What are the first one is term of copyright for the photograph. It's nearly doubled. 60 years from the publication to 60 years from the date of the photograph. So it is very difficult sometimes to find the original author of that photograph. Copyright term, duration of the all copyrights are above the minimum required by our international obligation. If you compare with the international obligation, 2012 amendment gives you it is give all the minimum requirement of duration is doubled. So if you compare with the international, we are we are in the loss of that opportunity miss. For example, what we had done the good thing, then we had done the what is the bad and what we had missed in that amendment. Educational exception, a detailed educational exception they had not shared. Communication to the public, of course, they had missed to communicate to the public. Internet intermediaries, they didn't give the more protection to the internet intermediaries. Fair dealing guidelines. They had not provided the proper fair dealing guidelines to the users what can be avoided and what cannot be avoided. Even they had missed the user and small creators. They had kept left out of the discussion. This is again missed opportunity. So libraries and single librarians was not called for the standing committee. Stakeholder like consumer, story and teachers, students, RT activists, independent publishers are not seen as a legitimate interested parties in the copyright debate. They should invite them and they get the input from them. So Parliament Standing Committee report IPR regime in India released on 2020 on July 23. The conflict arising between copyright holder and education institute due to exception contained 52A, 52.1. The committee recommends department to facilitate fair and equitable ecosystem. They asked literature to in country by bringing necessary changes in the 52 51A subsection 1 of the act, such as permitting reproductive work in government owned education institute and the storing in library for the easy access to the student, as well as stimulating the limitation to the unrestricted commercial grant to copy books and literary works and storage of copyright in digital format. So all these are covered in this 2012 amendment. There are certain important cases which is related to the copyright. Delhi University photocopy case. The committee has informed about the amendment to the made to the limit benefit of the exception in the provision of Copyright Act. What had happened in this case? They are making a numerous copy of the course material and sending and reselling to the student. And three Western countries publisher had filed the cases. But at the end of the day, what happened under the fair use clause? They had taken back that cases. But if you ask me ethically, it was wrong. But here's something a very positive note for the Indian, as we had amended Copyright Act 2012, but the same after our amendment in 2013, that is Marrakesh Treaty was signed in 2013 27 June by taking consideration of our 2012 amendment. Yes, so it means India had taken first standards in terms of giving rights to the disabled people. Then in 2013, a treaty has signed WIPO, a kingdom of Morocco at Marrakesh. The first country, India has become the first country to sign the Marrakesh Treaty on June 30th, 2014. An Indian Copyright Amendment Act is coordination with the Marrakesh Treaty. So, what is the Marrakesh Treaty? See, millions of people in the world who are blind or visually impaired will be able to read books in accessible format. It means those who countries sign this treaty, they are ready to exchange their literary and they are ready To convert that printed into much needed visual impact, accessible format, there is no copyright restriction. So, friends, we are at the third part of the session. And what is the copyright versus the plagiarism? Here, I want to highlight the basic difference between the copyright and the plagiarism. Uh, Using copyright, someone plagiarism using someone else's words without giving them credit. Typically deals with the word legally but highly unethically. Can lead to zero credit on assignments or being kicked out of college. Copyright using someone else's work without permission. Video includes word, pictures, video, music, etc. Both print and online, publish and unpublished. Yes, illegally, it can be considered illegally, can lead to court fines, jail time. So very simple terms how it can be differentiated. Copyright is a legal term, plagiarism is not a legal term. Copyright is a civil crime, plagiarism is an academic crime. Copyright unauthorized use of someone else's creative work, whereas plagiarism claiming or appearing to claim ownership of someone else's creative work. Monetary damage in copyright, monetary damages, and in plagiarism not punishable by government but by the academic sanction. So before going in a detail in the plagiarism, I'll have a short story. A and B are very good friends. B attempt to try to steal A's cat, but he got caught. What is the lesson? We learn an important lesson. You can just take somebody cat, but without asking for permission, that is wrong. You have to take the permission and then you can take it. Second, lessons from this story. See, when B succeeded taking that cat outside, he also tell the he didn't tell the truth to the friends. He just mentioned that this cat is his own. So lesson is that you should tell the truth to the people. Yes, I had carried from that person, but I'm giving credit to him. To conclude on this story, is it okay to borrow other people word picture story as long as yes, it is okay, but you have to take the first and get the permission. You have to ask first and get the permission. Second one is you have to give credit to the person from whom you are borrowing. Then there is no issue. So what is plagiarism? The word plagiarism comes from the Latin plagiaris meaning kidnapper. It means you are kidnapping something. The plagiarism, the act of presenting another works or idea as your own. किसी और का माल किसी और की कहानी मैं मेरे नाम पे करूं. That is called plagiarism. So definition, if you ask me, Merriam-Webster dictionary, the act of using another person's words or ideas without giving credit to that person, that is plagiarism. If you ask me, definition from the Pulse and Shield 2013, page number 1, plagiarism is a specific form of cheating and is generally defined as presenting someone else's work as your own. Of course, it can be termed it as a theft. Of course, it can be termed it as a cheating. And if you got red-handedly, then the result will be failing zero. Yes, then the result can be becoming a fail also. So what considered presenting another work, it is a plagiarism. Using words and ideas without giving credit, that is the plagiarism. Not using proper quotation marks properly, that is the plagiarism. Giving incorrect information about the cited sources, again, this is the plagiarism. Copying such large amount of ideas or words that is not majorly yours, that is also plagiarism. So there might be two types of accidental and accidental plagiarism. Not knowing when to quote, when to cite, not knowing how to paraphrase or summarize, not knowing what common knowledge, or recycling of old paper. This can be termed under the accidental plagiarism. Again, but if it is a intentional or accidentally, plagiarism means plagiarism. So what is not plagiarism? All quoted works reproduced with all necessary attribution, all references, bibliographic, table of contents, and acknowledgement. All generic terms, laws, standard symbols, and standard equations are not plagiarism. Exclude common knowledge or coincidental terms up to 14 consecutive words. That is not plagiarism. Deliberately, I told you, There is the accidental and another one is deliberately. Rewriting from the books or articles, copying and pasting, buying, downloading or borrowing a paper. This is called deliberately. Again, it might be accidental or deliberately. If you caught, it is the again. If you got caught, then definitely the problematic situation will be for you in terms of academic sanctions. Whatever exercise generally students are giving when they caught in terms of plagiarism. My teacher expect too much. I have to get into certain college. It's okay if I don't get a caught. Everyone does it, that's why I also do it. My parents expect A plus. So such type of excuses are given by the students to the inquiry committee while they are doing the plagiarism. Types and how to avoid it. Clone submitting another word for word as your own किसी और का लेना और खुद के नाम पे छपाना. Control C contains significant portion of the text from single sources without alteration. Copy कर रहे paste कर रहे without any alteration. That is another type. Find and replace, very important.
Sir, please unmute करा sir. Hello? You're not audible, sir.
आवाज येते आता. हॅलो.
Yes, sir. Yes, sir.
कुठून गेला होता आवाज, काय आयडिया आहे?
नाही sir. You just
मी रिसायकल पासून चालू करतो. ओके.
okay, sir. Okay.
स्लाइड मागे गेलो. कॉल तुझा कॉल आला होता म्हणते सर. ठीक आहे. Recycle, borrow generously from the writer's previous work without citation. म्हणजे त्याच्यात आधीचे पेपर मधून कॉपी करून नवीन पेपर बनवला, दॅट इज रिसायकल. हायब्रिड, combine perfectly cited sources with copied passages without citation. Perfectly copy केले but without citation. Mashup, mix copy material from multiple sources and presenting your own. Error, include citation but non-existent. It means inaccurate information about the sources. That is called 404 error. Aggregator includes proper citation to sources, but the paper contains almost no original work. Citation are okay, but the paper doesn't contain. For the namesake, they had provided. Retweet includes proper citation, but relies too closely on the text original wording and or structure from the original one. So these are the different types of plagiarism. How to avoid this? Write from the scratch, use quotation marks, paraphrase and summarize, then provide complete citation. You should know when to cite. Tips, tap on sources. You should be aware of types of plagiarism. You should also aware of plagiarism checker. And in last, you take advice from your professor or your guide. So to avoid to get into good in research, UGC had come up with a regulation in its 530th meeting held on 20th March 2018. And this regulation have been notified on the official Gazette of India on 31st July 2018. The regulation name is UGC Promotion of Academic Integrity and Prevention of Plagiarism in Higher Educational Institution Regulation 2018. So many people can ask, sir, उसके पहले का क्या? उसके पहले का राम भरोसे. But from 2018, they are very much careful. So objective of this UGC regulation, creating awareness, prevention of misconduct, establishing an institutional mechanism, promotion of academic integrity, prevention of plagiarism, setting up a system for catching plagiarism. Overall objective of this regulation is to create a free environment, to create a ethical environment for publishing your work. It means zero plagiarism policy. So definition, according to the UGC definition, plagiarism means a practice of taking someone else's work or idea and passing them as your own word. Okay, that is the definition. Script, research paper, thesis, study project, report, assignment, dissertation, any such work submitted for the assessment, opinion leading to the award or degree of publication in print or electronic media by student or faculty of higher education institution. So script means that your research paper script, thesis, project report, where you get the degree, that is called as a script. So it is restricted to HEI, it is restricted to university, any institute that has been declared by the parliament, any institute that provide education after 12 or a year of schooling and which provide degree or diploma after completing. So duties of HEI, just like your institutes, they are doing by conducting this workshop. What is their duties? To establish a mechanism regarding how to spread the awareness, to organize seminar for students, faculty, and other members. There you are doing already. Academic ethics you should cover in the graduate and postgraduate coursework. Research and publication ethics should be covered in PhD and MPhil scholars. You should provide proper training to the softwares which is available for the plagiarism checker. You should also provide established for checking plagiarism to your teaching faculty and students. So, what is exempted? Quoted work is exempted. Similar content is exempted. All reference, table of contents, preface, acknowledgement, and bibliography are exempted. Standard equation and symbols, laws, and generic terms are exempted. Zero tolerance, yes, of course. In some area, there is a zero tolerance. Hello, hello.
Ah, yes, sir.
I'm audible. Na?
Yes, yes.
So, what are the zero tolerance area? Hypothesis, recommendations, abstracts, summary, conclusion, results, and observations. So, suppose they had quantified up to 10% as per this regulation excluded. Between 10 to 40%, level 1 charges will be there. From 40 to 60% level 2 charges are there, and above 60% level 3 charges are there. So, we'll just check. In these regulations, they had created two panel, department academic integrity panel, and another one is institutional academic integrity panel from the HEI to investigate matter. Higher authorities DAIP who will investigate and provide its recommendation to the AAIB for of the HEI. So, what are the punishment of that? Level of that level of crime, which I discussed with you about this level. So in up to 10%, no penalty for both student and faculty. 10 to 40, that is level 1. For PhD student, revision of script within 6 months. For faculty, has to withdraw manuscript. Even it is very strict for the faculty. In 10 to 40% में उनको withdraw करना पड़ेगा. For 40 to 60% for PhD student cannot submit the revised script for cannot submit cannot submit the revised script for 1 year. 40 to 60% no supervision power for 2 years. For 60% cancellation of registration for PhD student. For faculty, no supervision power for 3 years. It means if you compare, the punishment is higher for the faculty as compared to the students. Even HEA, if I include head of the higher education institute, he can also have to go proper inquiry. So even he is also not exempted from this regulation. Content to be checked under the UGC regulation, research papers, thesis, chapters, any other similar work, full-fledged books, dissertation. So according to the UGC public notice on self-plagiarism dated 20th April 2020, even reproducing text recycling of your own paper, it is also plagiarism if you are not quoting properly, and it is not acceptable. So strategy to avoid plagiarism, how can you avoid? Quite simple, cite your sources, quote, paraphrase and summary. You have to quote it, paraphrase and summary. Some of the landmark incident which is happening in India, chemistry professor accused of plagiarism more than 70 articles. It is from the Venkateshwara University, banned their chemistry professor. More than 70 articles found from 2024 to from 2004 to 2007. Another one is Stanford University wrote to late President APJ Abdul Kalam about Professor Rajput plagiarism. In the year 2002, October, late President APJ Abdul Kalam received a letter from the Stanford University. In this letter, they had claimed that physics professor Rajput has bluntly copied from other sources. One of the signatory of his letter was Renaud Collar. So such type of incidents are now getting highlighted and they are, getting caught. Then plagiarism accusation of Dr. Sangilandi Gurunathan and his Karup. In November-December 2010, edition of the Biotechnology Advanced Journal brought out a notice that accused Gurunathan and his group of plagiarism and article division of polycolor. This accusation led to retraction of paper from the journal. See, this is the power of regulation. They retract that article from the journal. So detection of plagiarism, it is now, it was not easy in the print area, but in the digital area, it become very easy. Technology made it easier to track down and identify plagiarism. Search engines can easily detect full text journal articles in library database. Due to this, it is easily possible. Then free and commercial plagiarism detection service available. You can use it. Your instructor may well recognize sources. Free tools which is available for the check plagiarism, duplicate checker, copy leaks, paper rater, all this available on the underline. Commercial authenticate, Belgium, Turnitin, Urkun, Flag Scan. These are the. This is just taken from the Grammarly. I just copied and it is showing me it is 100% copied. So it is better you should start from the scratch. So conclusion is that you can I can show you as a guide. The guide will show you, but you have to understand and present it properly. Otherwise, it will be difficult for you to go through for that process without any without any hurdle. So it is better start from the scratch, make it a habit of taking a note and cite it whenever it is required. Thank you so much. If there is any questions, I'm happy to answer your queries.
Hello, sir.
Yes, yes.
So I would like to ask participants if there are any question about the whole presentation. Please put your questions in the chat box.
Of course, it is a copyright infringement if some movies are available on the third-party app without providing a proper approval. It is a it is a copyright infringement. Yes. Long time back, what happened? One of the photographer, which is very famous, what he had done, and who is held accountable then the founder who has provided the platform or the person who has uploaded. According to law, the person who had uploaded, and definitely, but the founder will also get into the act because he had provided the platform. But the major credibility on the person who had uploaded because there was an agreement by the Telegram what you have to upload and what you have not to upload. So one of the photograph, what he had done, he had provided all the photographs on the internet, his own photography. And after 6 months, he had checked where his photos get been copied, and he had sorted out near about 51 to 60 incidents where his photographs copied. Out of 61, he had sent 31 a copyright infringement because they had used for the commercial purpose. And out of court, he had made a huge profit from that incident. So you have to be very careful what type of information you are using and what type of information you are publishing. That is really important.
Sir, indeed, it was a very wonderful session. Let us wait if there are more questions.
Yes, ma'am. Yes.
I think the questions are not there. Uh, is there anybody who is asking? Sir, can you just read, sir?
Yes, social media apps
Question.
use personal data. Of course, you have to give your consent or not. They are using it. It's very simple. When I search for a flight for a Delhi, the next day I am getting advertisement on my Gmail and Yahoo for analytics and marketing techniques. Yes, they are using it. मेरी डॉटर 10 में मेरे से पहले मेरे क्लासेस वाले को पता चल जाता है. Our data is being stolen. So that's why there is a act is going to come very soon on personal data that will provide some helping hand to us in that we can protect ourselves in terms of personal data.
I think the questions are resolved by sir already. If there is anything else, we'll just wait for 1 minute. Okay, sir. I think if there are some questions, we can have that in the WhatsApp group also later on. I would just like to conclude this session. Prahlad Jadhav, sir, it was a wonderful session because the PPT itself was looking very good since the starting, and it was full of pictures. So the concept's clarity was too good since the PPT was started. You covered copyright understanding in a thorough way, which was really helpful to us to understand copyright and plagiarism in depth, why it is important, what it includes, such as literally artistic works, sound recordings, etc. So all the amendment till the date and what is related to it, plagiarism versus copyright, and with examples, what you have explained was wonderful, sir. We have understood plagiarism in depth with examples what you have given. So I thank you, sir. Thank you very much for the wonderful session which you have which you have presented here, and I'm sure that many of the users or these participants will get the benefit of this. I have with me our principal Dr. Vilas Patil, sir, who will be chairing the valedictory function today. So I thank you once again, Prahlad Jadhav, sir, and we'll move towards the valedictory function. So I request now Principal Dr. Patil sir to give his remarkable insights on this throughout sessions as a valedictory chairperson. Thank you, sir.
Thank you, madam. Good afternoon, one and all. As we come to the close of this one-day online seminar on intellectual property rights in research and higher education, it is my privilege to deliver the valedictory address. Today's seminar has been truly enriching and insightful. The session have provided us with a deeper understanding of the significance of intellectual property rights in the academic and research ecosystem. From the fundamentals of IPR to its practical applications in higher education and innovation, the knowledge shared today will guide us in our academic and professional pursuit. I would like to express my heartfelt gratitude to all our three distinguished speakers for their excellent presentations and valuable insights. I thank Mr. Prahlad Jadhav, Dr. Suvarna Nilak, and Dr. Krunal Kumar Kamani for sharing their valuable insights on IPR. Their expertise and clarity have helped us appreciate the importance of protecting intellectual creations, maintaining academic integrity, and promoting innovation. I also take this opportunity to sincerely thank the organizing committee for their dedicated efforts in planning and executing this seminar so effectively. The seamless coordination and thoughtful arrangements have ensured the success of this program. My appreciation also goes to all the participants for their active involvement and keen interest throughout the sessions. Your engagement has made this seminar lively and meaningful. As we conclude, let us carry forward the knowledge and awareness gained today and strive to incorporate ethical research practices and respect for intellectual property in our work. By doing so, we contribute to a culture of innovation, integrity, and excellence in higher education. With these words, I declare this seminar formally concluded and wish you all success in your future endeavor. Thank you. Thank you very much.
Thank you, sir. So I'll take this opportunity to thank each and everyone at the end of this seminar. I thank all the resource persons who joined and guided us today on the theme IPR. Dr. Kamani sir, Nilak madam, and Jadhav sir for covering almost all the aspects of IPR in the whole seminar. I thank our management patrons and Honorable Mrs. Pramilatai Gaikwad, Secretary of Akhila Bharatiya Maratha Shikshan Parishad Pune, for always encouraging and guiding us. I especially thank to our principal, Dr. Vilas Patil sir, for not only chairing the sessions but also motivating us to organize such programs. I thank Chairperson Dr. Sunanda Wagmare Madam for chairing a session. I thank all the head of the departments, Dr. Ramesh Desai sir and Jadhav sir, for organizing this event successfully. I thank Dr. Ganesh Madhe sir for coordinating and looking after and arranging all the technical aspects today. I thank all the faculty members of our college and their constant support. I thank Mr. Sanjay Shinde sir, who is OS of the college, and all my library staff for supporting today's program. Last but not least, I thank all the participants for attending the complete program. It was, I could see that almost 100 people were there throughout the day. So thanks to all the participants for actively engaging in this seminar. Link of feedback will be sent to WhatsApp group by today, and then e-certificates will be made available to WhatsApp group only. So I thank, and this IPR session seminar is over hereby. That will be declared, that is declared by this concluding vote of thanks. So thank you, and stay tuned and keep connected. Thank you so much.
Thank you.
Thank you, sir. Thank you, madam.